Okay, good evening, everyone. Thank you for your patience. We'll get this meeting started. We are talking about correspondence that's submitted late in this process. And many of you had your correspondence in early. We only have a week to read. In this case, I think we're over 400 pages. Last month, it was 700 pages. So, in the couple hours I have free between the time we meet and now, I'm not reading some of this. I haven't had a chance to. And it's not fair to the people on either side of these arguments. So I'm going to do, in fairness to this process, we're going to try to move through as fairly to the people who have their full arguments in and we had time to appropriately consider before looking at some of this stuff here, which I frankly haven't seen. So with that in mind, let's talk about the agenda a little bit and how we move forward. I would propose that we take a moment before we have something on Gaddis and we have something on quite a bit on the CMBC 1784 short-term rental changes. I would propose we look at that for each of those items, not now while everybody else waits. Does that sound like something that sounds fair to everybody else? Yeah. Eric, I see you nodding. Aaron, I got a thumbs up. Okay, good. Sign language works. All right, so that's what we'll do. So may I have a motion to approve the agenda?
So moved.
Seconded.
Any further discussion? Okay, Tessa, will you call the roll, please?
Commissioner Matusik,
Yes.
Commissioner Ostrander,
Yes.
Commissioner Sinclair,
Yes.
Commissioner Moritz,
Yes.
Commissioner Orloff,
Yes.
Commissioner Bates,
Yes.
Chair Newton.
Yes. Consideration of the minutes from our July 30th and August 22nd meeting. Are there any amendments to those minutes?
I had one amendment that I noticed on the minutes for the 22nd. In action item 2, consideration, when we considered the minutes from the previous meeting, it says Commissioner Eric. I believe it should have my last name there. Commissioner Ostrander, because then it continues who voted as last names there.
Thank you.
Good catch. Any other changes? Okay, there's no other changes. May I have a motion to approve the minutes?
Motion to approve minutes.
Second.
Any further discussion? Okay, Tessa, will you call the vote, please?
I think so. Let's bring it back if I'm not.
Aaron, I think you're still you're
Oh.
not.
Sorry, I'm a disaster. Thanks.
Commissioner Sinclair,
Yes.
Commissioner Bates,
Yes.
Commissioner Moritz,
Yes.
Commissioner Matusik,
Yes.
Commissioner Ostrander,
Yes.
Commissioner Orloff,
Yes.
Chair Newton.
Yes. We'll move to the public comment. Is there anyone who would like to come forward at this time and offer public comment that you believe is within the purview of the Planning Commission? If you would, or do have public comment, we ask that you limit that to 3 minutes. State your name, first receive recognition from me, state your full name and mailing address, and then come forward with anything you think is important for us to hear. Would anyone like to come forward this time in the audience? Okay, is there anyone online that would like to offer public comment? Okay, that's a no, Robert. Yeah, true. We'll move on. Our first item tonight is a legislative. Before we jump into this, I'm just going to give a quick description of a couple of the different processes. Have judicial processes tonight, have legislative. Is there just there's 2? So in a quasi-judicial process, this group acts as a governing body, as a quasi-judicial body. We will rule on as the findings and testimony presented. If inevitably there is one person that, or one group that's very happy and one group that maybe not as happy, you have the right to appeal our decision to the city council if you're not satisfied with our decision. If you feel that there are questions that you were not adequately prepared to answer, you may ask for a continuation. We will grant the first continuation. After that, because we only have 120 days as a city to entirely rule on any one application, probably won't grant another application unless there's extenuating circumstances. I think that's probably enough color on this evening. If there's questions, please ask as we're moving along. All right, so now let's jump into our first item. This is a legislative regarding continuation of ZO 2402, continuation City of Cannon Beach request for text amendment to Municipal Code Chapter 17.70 tree removal and protection. The text amendment request will be reviewed against the criteria of the Municipal Code 17.86.070A, amendments criteria to the statewide planning goals. Does anyone object to the jurisdiction of the Planning Commission to hear this matter at this time? Does any commission member believe he or she has a conflict of interest or a personal bias?
As advised by the Oregon Government Ethics Executive Director, I'm required to state that due to my professional business as a commercial and residential designer, that I have a potential of interest in regarding to ZO 24-02.
Okay. Have you thought about what that might mean practically in terms?
It's just due to the fact of what my professional business is, that there is a potential for conflict of interest. It does not prohibit me from discussing or voting on the amendment. But as this is just a continuation, then
Sure.
I can
Sure.
Jay, I just had one question. Do you have any current clients who will be affected by this code?
that will be affected by this code. I will always have clients that may be affected by this.
Okay, all right. The reason is they were talking about a potential and you might have an actual, so you would know if you have.
Whether I have clients now or in the future, I will always have clients because of this.
Okay.
Then how is it not an actual conflict?
As potential, I may have clients that may be affected by it. I do not know of them in the future. I am working with clients that will have to have tree removal currently, but as this code is not in effect, it is not a potential in my opinion. Or a direct conflict, it is a potential.
Well, I know we. Someone has their hand up. Bill, please go ahead. Our city attorney, please go ahead.
Thank you, Chair and members of the commission. And I just wanted to weigh in and talk a little bit about conflict of interest and how that sort of plays out in legislative proceedings. And the critical question for any commissioner, including Commissioner Orloff, is whether or not he, his family members, or his business would be affected financially, either to the positive or to the negative. If a change would definitely impact him, that's a actual conflict of interest, and he's required to declare that and not participate. If it may affect him, we don't know, it may increase, it may decrease, it may do nothing, then all he has to do is say, declare that it may affect him, and then he can still participate. And so the critical question is whether this code change, these code changes would financially impact Mr. Orloff, his clients, or not his clients, Mr. Orloff, his family, or his business. And if somebody owned a big piece of property that was timbered, that may well affect, have a realistic effect. However, what this will do is probably have an effect on his clients, which are not him, his family, or his business. It may be that his clients say, with these new tree codes, I can't do anything. I don't want to hire you, and its firm profits go down. It may be that it gets much more complex and he has to do more work and his profits go up. So I think what Mr. Orloff has indicated is that this could have an effect on me. possibly, that it's a potential conflict of interest, but we just don't know. And in that situation, he would be allowed to participate on these legislative changes.
Okay, thank you, Bill.
Any questions, or does that make sense?
Mhm.
Questions? Okay. Thank you for that. We'll move ahead. But with no questions or comments, we will move ahead. Has any commission member had any ex parte contacts or made a site visit? Yes. Guess we wouldn't have a site visit on it. would we?
I'm trying to imagine that. How's that gonna work?
We visited the trees, the paper was turned on. Okay. You guys want to give us that report? Yes.
Good evening. At the July 25th, 2024 meeting, the Planning Commission continued the hearing regarding the proposed amendments to section 1770, tree removal and protection, until their regularly scheduled meeting on September 26, 2024. This meeting, in order for the tree focus group to continue work on the proposed ordinance amendments. Recently, city staff received a request from the tree focus group to continue this matter until the October 24th, 2024 Planning Commission meeting, because the group needs more time to prepare the information for Planning Commission consideration. Staff recommends that the Planning Commission grant this continuation until the October 24th, 2024 Planning Commission meeting.
Thank you.
Can we give you an update on status, just so you know what we're doing?
That would be great. Yeah.
Les, you want to do it, or would you like me to?
Why don't you go ahead?
So we're pretty much done with the drafting. We've polled everybody in the city. We have located an expert who has looked at it and has blessed it. That person, I think, I'm looking, from ODF will be here on the 24th. To answer questions and share her thoughts on it. And I think the last thing we need to do is probably, and I'm not sure where we are on this, is just wrap Bill into the process. And so is there anything else? Mr. Biasman?
Yeah, no, I think that we're very close. One of the reasons I think we did not want to bring it forward tonight is we wanted to allow extra time for it to be published for everyone to get a chance to really look at it. And you're right, it may need to run by Mr. Kabison one more time, but we're very, very close.
Okay. So
we would probably, I think, anticipate presenting this perhaps for adoption on the 24th.
Will there be a preview of them?
The preview will be, the document will be online quite soon, and you will have a whole month to look at it. We haven't planned another meeting. I'm not sure that, are you requesting it?
Yeah, I mean, would like more than a couple of days to review it.
Oh, yeah, well, you'll have 28 days.
Will it be publicly?
Yeah, publicly available. It'll be on the website.
Okay.
So we've continued this once already.
Mhm.
There may be some people who've come on this issue
I don't know.
tonight. Do we want to discuss public testimony, or do we want to just move straight to continuing?
Let's hear whoever wants to talk, I think, yeah.
Yes, for talk.
Second.
I just question if there isn't proposed language in front of us
Some inefficiency, you're right.
that seems inefficient.
Absolutely inefficient.
Yeah.
Yeah,
I agree. I'm trying to be,
we can certainly ask, but I don't think it's a very efficient use of time.
what if we limited?
Yeah, we could limit it.
Okay.
Yeah, we could do that.
Is there anyone in the audience here who came to speak on the tree ordinance tonight? Or online? Is there anyone online who came to speak on the tree ordinance? Okay, then let's move to our consideration. We have a motion to continue. Further discussion, or we have a request to continue. Does someone want to make a motion?
I'll move that we continue until the October 24th meeting.
Second?
I'll second that.
Second.
Second. Okay, Les, you have the second.
I have the second.
Any further discussion? Tessa, will you call the roll, please?
Commissioner Orloff,
Yes.
Commissioner Moritz,
Yes.
Commissioner Bates,
Yes.
Commissioner Sinclair,
Yes.
Commissioner Matusik,
Yes.
Commissioner Ostrander,
Yes.
Chair Newton.
Yes. BO 2402 is continued until our October 24th Planning Commission meeting. Okay, moving ahead to our next item. Quasi judicial hearing regarding public hearing 24-07 and SR 2403 CEDA requesting a variance and setback reduction. CEDA application for variance to the off-street parking requirements for reduction of the required front yard setback in conjunction with the Cannon Beach Elementary School rejuvenation project. The property is located at 268 Beaver Street, tax lots 4,000, 4,100, 4,101, 4,200, 4,300, map 51020 CB. In an institutional zone. These applications will be reviewed against the criteria of CBMC 17.90 variances and 17.64 setback reductions. Does anyone object to the does anyone object to the jurisdiction of the Planning Commission to hear this matter at this time? Does any commission member believe he or she has a conflict of interest or a personal bias? Has any commission member had any ex parte contacts or made a site visit?
Site visit.
Site visit. Okay. Go to staff report, please.
Thank you. In the interest of time, I'm going to try to keep my comments brief. The applicant, CDUB, on behalf of the city of Cannon Beach, requests a variance to exempt the city from meeting minimum required off-street parking requirements. Additionally, a setback reduction request for the front portion of the property facing Beaver Street for the purpose of accommodating planned pedestrian improvements and amenities is requested. Both actions were previously approved by the Planning Commission in 2023 in files V number 2301 and SR number 2305. However, these authorizations expired as a building permit was not issued within 1 year of the date of the approvals. The city is seeking approval to reestablish the same variances in order for the project to be able to move forward. The applicable criteria include 1790-070 off-street parking and loading facilities. And the summary of the staff comment is that this application seeks to provide alternatives to the previously discussed undesirable outcomes that would result from a strict or literal application of the off-street parking requirements. As this is an adaptive reuse project, it seeks to minimize the amount of new construction and provide community enhancing open space. The city and its consultants are required to fulfill the project's objectives within the space available. Additionally, the Planning Commission has determined previously that the tourism-oriented center is unlikely to be consistently operating at full capacity on a regular basis and may operate at times that do not create a conflict with other uses in the area. Moving into section 1764 setback reduction. The comment is that the former elementary school building is a non-conforming structure which is built out to the property's southern boundary line. Planned pedestrian improvements include new and wider sidewalks along the north side of Beaver Street and an entry pavilion that will be located along the front of the gym building and a planned addition that will connect the gym to the classroom building. The proposed changes to the Beaver Street right-of-way will not provide an adequate amount of space to make the structure compliant with current standards. However, even with the proposed entry area, the setback would be increased to a total of 15 feet, which would be a significantly larger setback than is currently present. Also, a comment received by the Cannon Beach Rural Fire Protection District did identify an issue on South Beaver Street right-of-way that can be addressed through roadway improvements. Proposed condition of approval number 1 will require the city to pave the currently gravel area in front of 267 and 269 Beaver Street in order to resolve this concern by increasing the width of the improved roadway. And that concludes the staff report.
Okay, was there any additional correspondence?
Nothing
Yeah,
Beyond the comment that was received and distributed yesterday, there were two comments received, one from Ms. Duber and then the other from Jeffrey Kleinman. Both of those were forwarded to the planning commission yesterday.
yeah, and I can address those just a little bit. I think the attorney Kleinman one was, there was just a lot of discussion in the past about a one-way. And there were concerns for Mr. Maloney about the Beaver Street being one way. That is not going to happen. This is totally dedicated as a two-way street. So, and that was taken care of, and that's what all the improvements show. And then Anita Duber has requested, I respectfully request continuation of the agenda item. So at some point in time, when a request is for a continuance, we have to grant them in the first evidentiary hearing, but at that point in time, we may want to also touch base with Bill a little bit in terms of what he thinks would be the best way to approach that.
So given that we have a request for a continuation, I would suggest that we limit public testimony to 3 minutes here. We're going to be seeing this again. And we have a huge agenda in front of us. We should try to move along. You all feel good about that?
Yeah, I was just wondering whether Steve was referring perhaps to the fact that this is actually the second evidentiary hearing, but I don't. And that's why you wanted to ask Bill first is, do we have that ability?
Right, I think even it's a new application.
Yeah.
So technically it would be considered the initial evidentiary hearing again. Bill, if you wanna, I don't know if there's anything you wanna chime in. The application was brought to the Plan Commission previously. Plan Commission approved it. There's a certain time period, a year, that you have to get before you get a building permit. That hasn't happened. That's why the application's back before you again. And then maybe Bill can touch base a little bit just from a continuation perspective.
Yeah, and unfortunately, this is the initial evidentiary hearing on this application. Even though many of the issues are going to be the same, it still is the initial application here with the right for a continuance or leaving the record open if someone makes that request.
Jay, did you have something?
The original application was both for the setback reduction variance and the parking variance.
That's correct. So in essence, the application or the staff report is very similar to what you had seen previously. Your first time. Yeah.
So all that is to say, we are going to move this, ultimately, we are going to move this agenda item to our next meeting, and we will have our discussion and ultimately our ruling at that time. But because many of you came here tonight to speak on this, we want to be respectful of you coming here. We'd ask you to limit your testimony to 3 minutes. So I'll give a more formal spiel here I have to cover. We'll now move to public testimony. The pertinent criteria to be considered are noted in the staff reports and listed in the criteria sheets on the meeting page of the city's website. Testimony, arguments, and evidence must be directed toward those criteria or other criteria in the comprehensive plan or municipal code which the person testifying believes apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal based on that issue. Prior to the conclusion of the initial evidentiary hearing, any participant may request an opportunity to present additional testimony, arguments, or evidence regarding the application. The Planning Commission shall grant such requests by continuing the public hearing or leaving the record open for additional written testimony, arguments, or evidence. Persons who testify shall first receive recognition from the chair, state their full name and mailing address, and if appearing in a representative capacity, identify whom they represent. Would anyone like to come forward? Please.
I'm Robert Maloney.
We want to have the applicant make their presentation first.
You know, that kind of rattled me. Mr. Mullen, will you forgive me? I fell out of order there a little bit. We'll have the applicant go and then you can go. Okay, so the applicant's going to, yeah, that the procedure.
Sounds.
Okay, is there a presentation by the applicant? Might be a few minutes, Mr. Mullen.
So right, go ahead.
No, I'm saying you might sit down. It's probably going to be a few minutes.
Oh, I'm sorry.
I'll make sure we.
Hi, can you all hear me?
Yes, we have you.
Great, thank you so much. Good evening, Chair Newton and commission members. My name is Dustin Johnson. I am representing CETA, the architect and engineer for the Cannon Beach Elementary project, and representing the city of Cannon Beach as the applicant. Apologies in advance if you hear a little background noise. We're actually on vacation right now at Great Wolf Lodge, and my kids just walked into the hotel room, so I apologize for that.
May we have, but not your Great Wolf Lodge address, but your business
Sure.
address for the record, please.
You bet. So our business address is 15895 Southwest 72nd Avenue, Suite
Thank you.
200, and that's in Portland, Oregon.
Thank you.
And I wanted to keep this real short. I know most or all of you are very familiar with this project pretty intimately. This has been in front of you several times. If requested, I'd be happy to go into detail about the ins and outs of this adaptive reuse project. But I would like to focus on just a couple of points, and that is, as Robert had mentioned, the off-street parking variance was brought forth to the Planning Commission in January of 2023 and approved. In a separate hearing, the setback reduction request was brought forward in June of 2023 and approved. I wanted to take the opportunity to just confirm to the Planning Commission that there have been no substantial modifications to the design that would affect how the setback reduction request or the parking variance were originally proposed. So there would be no modifications to those proposals. Secondly, while the city and its consultants, CETA and others, were very committed to meeting that 12-month timeline to finalizing the design development and submitting for and obtaining the necessary permits, it was the city council's, city council had opted to embrace the community outreach component of this project, which has been prevalent since the very beginning in the programming phase. We dedicated a couple more months to that process in order to hear from a larger cross-section of the Cannon Beach community. Again, not the only reason we weren't able to get in. It's a complex project. We needed more than the allotted 12 months to get into the permit, but the additional time for community outreach just exacerbated that a little bit. Beyond that, I'll wrap this up and I'll be available to answer any questions, or again, if additional information with regards to the specifics of the project is requested, I'll be here to give that analysis as well.
Thank you.
Thank you.
Are there additional presentations by the applicant? Okay, so now we'll move to proponents. Are there presentations by proponents of this project? No one online, Robert? Is there a presentation by opponents? If you're opposed to this?
No, I would be a proponent.
A proponent? Oh, I'm sorry. Please come ahead.
All right. I'll be very brief. My name is Robert Maloney. I am the owner of Sequoia Investment Company, which is my family company. We've owned this property at 79 North Spruce Street for years. And basically, I'm here really to thank Robert St. Clair and his staff and all of you for the work that you have done before tonight in connection with this project on a very professional and thoughtful support for the concerns that we have that have been resolved. And as part of this, I also want to say that my family feels strongly about this, that we're going to donate $1,000 to the project to be used for either artwork or something similar to that through the Native American tribe that is doing this, to set an example. So thank you very much.
Thank you for your testimony and generous gift to the project. Are there any other presentations by proponents? Okay, we'll move to presentations by opponents. No one? Your staff response?
Only response I would say is, in addition to the fabulous work Robert's done, that Bruce was probably a lot of the Dennis was probably a lot of the person that talked to Mr. Maloney to resolve some of those issues. So I just wanted to make sure that everyone was aware of that.
Sure. Keep it. Is there any final statements, any proponent or the applicant wishes to make at this time? Okay, then we'll close the public testimony portion of our consideration. We have a motion, we have a request to continue this item until next month. Seems to me there were two pieces to Anita Duber's letter.
Comment on another point too, though. I think that was a different matter.
What was the other point? Is that what?
That's right, because she did raise that DRB had denied.
Oh, and whether we had the jurisdiction
Right.
to hear it.
Right.
Will you summarize that? You'll do it better than me.
Sure. If I understand Ms. Duper's comment properly, there was an application for this same project before DRB, I believe, related to landscaping or exterior.
It was basically was the same the DRB submittal for the entire school project, which included the site plan, the landscaping, and the architecture. And the design review board had denied that, and I believe she wanted that information shared with you.
Okay. My understanding is that wouldn't affect our jurisdiction to consider separately parking and setback reduction.
That's correct.
It was just-
Those are variance requirements that, just like they did last time, have to come here and have the plan commission consider those requests and act upon them.
So that was purely a piece of information. It doesn't affect,
That's correct.
so you can move forward. Great.
The only other comment I had, I don't know if Bill, if you might want to, if there was any information you'd like to just comment on with regards to the continuation.
No, it's just, the only thing I would say is that in the past, the planning commission used a 777, which seems to set things up pretty well for the next set for your be able to make the decision that next meeting. Just to reiterate, the 777 as set out in statute, that allows 7 days until 5 o'clock, 1 week from tonight, for any person to submit any new evidence. And then 7 days after that till 5 o'clock, the next Thursday, for any person to respond to new evidence that came in during that first 7 days. And then a third 7-day period just for the applicant to submit any final written argument that the applicant wants to make. And then you come back to your next meeting and you're teed up to make a decision.
Okay. Thank you, Bill. How do people feel about the suggestion to have?
I think that's a good idea.
It's appropriate. Yeah.
On that 777, then we just come back and there is no public discussion, then we just rule on the record. How does that work?
That's
Did you
correct.
hear?
Yeah. You'll have all the evidence, all the testimony from any and all persons within 21 days of tonight. So you'll have all that information at least a week ahead of time, and there'll be no written testimony, no oral testimony. You just dive into deliberating and make a decision.
Everyone feel good about that?
Yeah, do we need a motion to go that way or?
Do it, yeah.
I move that we continue this on a 777 basis.
And it might be helpful for Steve or Robert to identify, what the dates are for the various pieces, just to make sure the record is complete for anybody who's paying attention and wants to know.
I do have the calendar up. So the first 7-day period would be Thursday, October 3rd. The second would be Thursday, October 10th. The third would be Thursday, October 17th. And then the next scheduled meeting would be Thursday, October 24th.
Okay. Do I have a second for the motion on
Second.
for the discussion? Okay, Tessa, you can call the roll.
Commissioner Bates,
Yes.
Commissioner Ostrander,
Yes.
Commissioner Orloff,
Yes.
Commissioner Woods,
Yes.
Commissioner Matusik,
Yes.
Commissioner Sinclair,
Yes.
Chair Newton.
Yes. E 2407 and SR 2403 is moved to our October meeting. Okay, moving on. Our next item is also a quasi judicial hearing, continuation of app 24-01. City Council remand of the Planning Commission's decision to SR 2401 Brent Burton requesting a section due to the required front and side yard setbacks in order to construct a single family dwelling on an undeveloped lot located near the intersection of South Hemlock and Central Streets. Subject property tax lot 4302 map 51030DD is located in a residential low density zone. The request will be reviewed under municipal code 17.4.0 setback reduction provisions established. Does anyone object to the jurisdiction of the Planning Commission to hear this matter at the time? Any commission member believe he or she has a conflict of interest or personal bias?
Do you mind if I ask a question, Jay? I don't want to put you on the spot, but I do know that most of the times you've come before us has been to request a setback reduction. And I know you recently argued against a denial of a setback reduction that we made. Do you feel that you're comfortable being unbiased, looking at setback reductions, given how often you've asked for them?
Yes, I feel I have no bias. Okay. And I will state that in my case statement.
Thanks.
It's interesting tonight. And this is going to be an interesting conversation for us, Jay.
It is.
So I'll refine my responses as we go.
We have a neighboring property, a wall we were concerned about, and you were involved in that permit.
Yes, the Taylors are my client.
And in the Burton's project, we have a wall or a geology, more broadly, the geology we're concerned about. I'm just kind of thinking this out loud here with you. There is similar concepts between the two, similar concerns. How do you segregate those where you were a consultant on one project that has a set of criteria we had to consider and we put in place that another project, the project we're considering right now, also potentially has?
Correct. They are similar, but they are different. Taylor project was a setback reduction only for a porch, where the Burton setback reduction is for a structure. House structure rather than a single possibly movable object, where the house is a set condition. And
That's fair.
again, I will make additional statement in my ex parte.
Sure.
We appreciate your openness
Yeah,
to
no,
these questions.
I am happy to answer any and all of them to the best of my ability.
Okay. I'm comfortable. Everybody else, any other questions? Good. So
I think this is just a conversation that's going to be ongoing. Fair warning, when we do get to talk about the Taylors again, I do have some concerns that I want to talk about, but I don't want to right now.
At that time, I will address that as well.
Okay. Has any commission member had any ex parte contacts or made a site visit?
Site visit.
Site visit?
Ex parte. I did talk to Brent Burton in regards to the Taylor project in July of 2024, but provided no professional analysis or compensation for this project. I've seen plans previously submitted to my appointment, which are the same that were submitted today. I informed Brent Burton on September 12th via email that I would be unable to provide any professional services due to the continuation of their setback variance request and my appointment to the City Commission Planning Commission Board. I received no compensation from the applicant at any time. I have no bias for or against the applicant or the application.
Just to be clear, did you at any point offer an opinion to Mr. Burton?
No.
Okay.
I only provided him the information from the Taylor Geological.
Got it. Okay. Okay. May we have the staff report, please?
Sure. The setback reduction requested by Mr. Burton is for a required front yard setback of 15 feet to 5 feet for the construction of a new single-family dwelling on the undeveloped lot near the intersection of South Hemlock and Center Streets. The applicant has indicated that setback reduction is needed to allow the house to be built on a portion of the lot that is less steep and will have less impact into the hillside, and to also meet the requirements for no parking or access to Hemlock Street. At the July 25th Plan Commission meeting, Mr. Burton requested this matter be continued in order to address questions and concerns raised during the meeting. The applicant has now submitted additional materials into the record that include, one, a new letter addressing the setback reduction criteria, and two, new attachments that he refers to as A8 through 17, which are included in the packet, which include emails, press articles, research paper information, site plans, water line information, and a typical streets section. The supplemental staff report is addressing only the materials submitted since the July 25th meeting. In the applicant's letter, he focuses his response and directs his concerns expressed by the Plan Commission hearing, and concludes the following concerning the newly submitted information. This is an application for a front yard setback reduction from 15 to 5 feet. It's not an application for a building permit. The criteria for approval have been met and the application should be approved. Without a 10-foot setback reduction, the applicant asserts that this will not be possible to use the west side access driveway from Center Street. The driveway was acquired with the intent to access the proposed house parking structure from the west and avoid entry or parking on Hemlock. At the March 28th, 2004 Plan Commission hearing, the applicable Cannon Beach Municipal Code 17.64.010 setback reduction was cited as the only Cannon Beach Municipal Code that would be reviewed to consider the application. Staff noted that prior to issuance of a building permit, city staff will review the development application for compliance with established standards for the zoning district, including criteria such as the inclusion of a geological hazard report specific to the proposed development, building height, lot coverage, floor area ratio, and off-street parking requirements. The applicant agrees with this requirement, but finds it to be unreasonable requirement to require a geological hazard report to accompany a setback reduction application. The applicant asserts that there is no rational reason to require the geologic hazard report prior to the setback reduction approval. The letter submitted by Earth Engineers and Vito Sorelli explained from experience in logistics why a geologic hazard report should follow, not precede the house design. There's a number of information and applicable criteria that I'm sure everyone's taken a look at, that Mr. Burton has cited and that we've discussed previously. That is some of that are regards to view, tree protection, neighboring views, unusual configuration, and adjacent rights of way. So if anyone has any specific questions on this information that's been submitted, or any information from the previous staff report that was fairly detailed as well, we're here to answer any questions.
Okay, thank you. Is there any additional correspondence? Okay. We'll move to public testimony. Pertinent criteria to be considered are noted in the staff report listed on the criteria sheets on the meeting page of the city's website. Testimony, arguments, and evidence must be towards those criteria or other criteria in the comprehensive plan or municipal code which the testifying believes apply to the decision. Failure to raise an issue accompanied by sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal based on that issue. Persons who testify shall first receive recognition from the chair, state their full name and mailing address, and if appearing in a representative capacity, identify whom they represent. Their presentation by the applicant.
Hello, Brent Burton here. I trust you can hear me. My address is P.O. Box 1938, North Plains, Oregon 97133.
Thank you.
Can you hear me okay?
Yes, go ahead, Mr. Burton.
Okay, and I think you heard from the staff report in pretty good detail that this this is a continuance from an original planning commission hearing that occurred in March, and was appealed to the city council and then remanded and now continued to the planning commission. And so you've probably heard much of what is in the staff report, as well as what I have presented. One thing I wanted to add at the start is I did send in some additional evidence that was too late to get into the staff report, but I wanted to make it part of the record. If it didn't get to the city, I'd like to have the opportunity to resend it. And that is a LUBA brief that was prepared by Carrie Richter in 2011, and Ms. Richter was representing the city. At the time, she was not employed by the same law firm that she is now, and now representing the city, but she was representing the city in an issue that involved two items that I'd like to emphasize, because they were a part of that hearing back in 2011, as well as this one, and that is specifically the addition of standards to the setback reduction application. Ms. Richter specifically stated that, along with much detail, that other standards, specifically the geotech survey, did not need to be considered to resolve the setback request. There was a great deal of discussion in her brief about why the geo hazard survey need not be addressed in the context of a setback reduction request. The setback reduction request should be decided, and then the geo hazard report should be generated during the permitting phase. And if it impacts the setback reduction, the setback reduction that's been granted, then of course that would be an indication that a different course of action must be taken. Ms. Richter also, I'm jumping ahead a little bit here, and I'll get back to the point about the view issues, but Ms. Richter in her brief also on the part of the city found that, and in quotes, and if the brief made it in, you can read in great detail how this was analyzed, that it did not make any difference whether it was 15 feet or 3 feet away from the property, that the view obstruction was similar. And because the petitioner in this case, which I had some direct involvement with, was considering some view impairments in a home that was being constructed on the ocean front. But the city approved the setback reduction and repudiated all of the arguments made by the petitioner in favor of Ms. Richter's arguments. And so all I'm asking now is that those same arguments be considered and adopted in the analysis of the setback reduction request that I'm making. So at the last hearing, we had a lot of discussion about the criteria of which one of three items must qualify, excuse me, must qualify for granting a setback reduction. And the three items that, although only one is required, I explained that we actually qualified for three of the items, which was tree protection, neighboring views, and unusual configuration. And of course, I acknowledge that tree protection is indirect in this case because obviously moving the building 10 feet to the east does not protect the trees that are being damaged by utility lines. But if those utility lines are placed underground, it does protect those trees. In addition, there's been nothing that I see that that the tree protection and undergrounding lines is beneficial in terms of emergency response. It's publicized, and I sent some documents to emphasize this. But it's emphasized that in the course of a major storm, tsunami, earthquake, or such, that one of the major hazards is taking down telephone poles as well as utility lines, which presents a significant hazard to persons or vehicles attempting to escape the dangerous area. So there's a dual advantage by having the setback reduction in this instance. But even if the tree protection is not a consideration, then neighboring views would qualify for granting the setback reduction. And I spelled this out in great detail at the commission's request by putting in some sight lines so that a person walking between properties and viewing through the front yard setback, the view obviously is going to change, and there's going to be some obstruction depending upon where the person or the person in the vehicle is positioned. However, as one travels north, the view actually improves by having the structure located further to the east, because it frees up 10 feet of building space. The advantage, disadvantage is about the same. There's a slight benefit to having the setback reduction in terms of improving the view versus having any view obstruction. And then unusual configuration was an issue that was challenged. That's just simply a look at the property as to whether it is unusual configuration, and that justifies consideration for a setback. There was a number. There was some argument about the need for a geologic survey to determine if there's unusual configuration or not. But the logic behind that it can't be satisfied by invoking a geologic survey. There's no relationship. Our lot is unusual because the city does not allow us to park on Hemlock. We can't have access off of Hemlock into the property, and that mandates building a driveway to the west, which we cannot use if we don't have a setback reduction, because we need that 10 feet to make the driveway long enough so that the slope going into the house is sufficiently excuse me, is sufficiently low to allow us to get into the garage. And that means that if we were to build the house without a setback reduction, the grade would be so steep that it would be prohibitive at greater than 30%. If we have the setback reduction, the driveway can be constructed in a way that it's still going to be steep. It'll be, but it can be less than 20 degrees. And I had my architect take a look at that and evaluate that data, and that's presented in the evidence packet as well. Okay, and then the right of way issue was not an issue at the original March hearing. At the March hearing, the water main was cited as the only issue that was considered to be an issue that would require denial of our application. And that's because it was proposed, it was believed that the water main was very close to the property, and it was so close to the property that would justify rejection of the setback reduction. But it was discovered and proven by Mr. Waters, a public works expert with many years of experience, and also a new locate that water main would be at least 15 feet away from any structure that's built with a setback reduction. That's a greater setback than would occur if the water main actually was built or existed. If the water main actually existed at the property line, which it does not. The water line, as shown in the documents and by the locate information, indicates that it is 10 feet from the property line, more than adequate for utility usage. So those are the points that that I wanted to talk about in response to the concerns and questions that arose at the last meeting. I'd be happy to address any additional questions at this time.
I have a question. Mr. Burton, the property on Forest Lawn, did it have a slope exceeding 20%?
The slope on the property is variable, but it's over 30%.
The property on Forest Lawn where you previously applied for setback reduction in 2011. I think I'm familiar with that property, but it doesn't have any slope on it, does it?
No, the property in question was an oceanfront property, and it was required to have a geologic survey conducted. The only issue that was being addressed at that time and presented by Ms. Richter in her brief was that the geologic hazard survey was going to be done no matter what, but it was when it was going to be done. In fact, one of the commissioners inquired specifically, as I'm suggesting, that they asked the question, well, is the hazard report going to be done whether or not we approve or deny this application? And the answer was yes, indicating that it's a requirement, but it's not a requirement. In fact, it makes no sense to do it prior to the setback reduction approval.
I think I could follow up a little bit here, and the reason I'm bringing it up now, Mr. Burton, is so that you're not surprised when we have further deliberation. I think there's a little bit of misunderstanding. The reason that we did a geotechnical report was not about whether this was an unusual configuration, but was out of concern for the requirement under 1764-010A5 that there not be an impingement upon either utilities or other public purposes. The concern is the stability of Hemlock. So the fact that this is your burden to meet every criteria to receive a setback, we were hoping that you would understand this would allow you to meet your burden, that in fact it would be safe. And that's why we asked for the geotechnical report. Also, I would just point out that at 17-108-030, I'm going to read this to you out of the city code. The city manager may require that the requirements of this section, this is a section on development in potential geologic hazard areas, may require that the requirements of this section may be met in conjunction with a request for the approval of a setback reduction. So that means that you have the ability to ask for a geotechnical permit while you are seeking a setback reduction and prior to obtaining a building permit. And if you'd like to respond, please feel free.
Okay, well, we'll go back to exactly the same issue that was dealt with back in 2011, and that was on an oceanfront property. And you could make the same argument that you should have a geotechnical geologic hazard report prior to doing any building. But the point that was made as a point of policy and law was that that the survey, the hazard survey, is going to be done anyway, and all you're doing is in granting a setback request is to identify a different area that you can apply for a building permit. It does not give the person the right to work around a geologic hazard survey. It only indicates that you can design a house to go in that space, and during the design and permitting process, then it's a requirement to obtain a geologic hazard survey. It makes no sense to do it prior to, because then we go through all the design processes only to find that there may be a need to totally redesign everything based upon that. But if we can do the design and then obtain the hazard report, that makes a lot more sense.
We'll discuss it later.
Any further comment from Mr. Burton or things that you think would be fair to have him address before we move ahead? Mr. Burton, did you have anything further as a part of your presentation?
No, I think we covered all the points, and I just wanted to make sure that the brief by Ms. Richter makes it into the record, because it's very important that she was basically arguing what I'm arguing now, but she was arguing on behalf of the city, not on my behalf.
That is in the record, Mr. Burton? It is. Yes. Okay, if there's nothing further, and we will come back to you as the applicant. Are there other proponents of this project application that would like to come forward this time? Okay, are there opponents who would like to come forward at this time? There's staff report? I said staff response. No. All right. So that curveball. Okay, Mr. Burton, is there anything final thoughts you'd like to leave with us before we close the record? Before we close public testimony?
Well, I think we've covered it. I've presented additional evidence to fill in any blanks that you might have. I think the evidence is very clear that if you read through the criteria of 17.64, that all of those criteria have been met, in addition to even better than those criteria, and that the setback reduction is a necessity in order to build on that lot. We must be able to have that setback reduction in order to use the use the driveway on the west side. And not being able to do that, it means that we're going to have to look back at either having parking and access off of Hemlock, which obviously the city would not be happy about. So we'd like to get that setback reduction done, and so we can use the property as we have planned, and at least up to this time had worked with the city to get the driveway in place so that we could access it from the west side.
Okay, thank you. Mr. Burton made a point there that I don't remember if we addressed. We've talked about this a number of times now. I do not remember if we addressed or had a conversation about the driveway.
We did.
In our last meeting, we did.
We did in March. That was a significant.
In March. So because it was remanded back to us, is that considered a part of this consideration?
Yes.
For sure. That's part of our criteria.
Okay, it's part of the
Oh,
whole.
yeah.
Okay,
No
good.
question.
Anything further, Mr. Burton, or may we close public testimony?
Can I ask him one question?
Of course.
No,
Mr. Burton, how would an alternative design that did not have to utilize a setback reduction affect you in regards to the driveway and the design and construction of the home?
No, I'm sorry, you're breaking up a bit. Would you mind repeating the question?
How would an alternative design that would not require a setback reduction impact the design, construction, in regards to the driveway, the house construction itself, that you would like to state?
Okay, well, I've had, well, the alternative would be to have access and parking off of Hemlock. But that's been prohibited since we started looking at the design back even prior to 2021. So that design alternative has basically been ruled out by the city. But on the other hand, we have not opposed not having parking and access off of Hemlock if we can get if we can use the driveway on the west side. And the prohibition, of course, is that the driveway is positioned so that to get into the parking structure, that we have to climb a grade that without a setback reduction would be totally prohibitive at greater than 30%. But with the setback reduction and lengthening the driveway the 10 feet, then we can make the driveway, albeit still steep, but it would be doable.
Could I follow up? Because as I recall in March, Mr. Sorelli was here. He talked to us about the plans, and the two alternatives were either about approximately a 20% driveway with the setback reduction. Without the setback reduction, it was a 26% driveway. It was not 30. And he also did acknowledge that if you were to bring the driveway around in a curve, that could be done. He just said you didn't want to cover your lot with that much asphalt.
Well, if we make the driveway too extensive, it may run into a coverage issue. In other words, it's my understanding that we cannot cover the lot with pavement up to a certain extent. And then also that sort of begs the question as to how that would have an impact on the geology as well. And you've already heard from one of my neighbors, the Newports, that they don't want, they're concerned about building the house into the hillside, and also with a long driveway that's wrapping around the house, because it takes out a lot of green space as well.
Any further questions for Mr. Burton? Mr. Burton, any final thoughts before we close the public testimony?
Not unless there are any questions. I'll be here for any questions if you have any.
Okay, we're going to close the record, so we won't have any more questions unless we reopen the record. So at this point, we'll close the public record. Thank you, or the public testimony portion, and move to our deliberation. Who would like to start?
I'm happy to start. Unusual configuration generally means that a lot is unbuildable unless a setback reduction is granted. And in this case, there's no way that I can imagine that it's literally unbuildable. It may mean that a garage is detached rather than attached. It may mean a driveway that goes somewhere that you don't want it to go, but it's not as though it's even a requirement that there be access off of Hemlock. Because from my site visit, it is pretty obvious that yes, there are ways to access a home built within the existing setback. So I do not believe that that criteria is met. Tree protection, I see that I don't understand even the argument, but what I hear and the best that I'm interpreting is that Mr. Burton is saying he will order taking down some power lines so that some trees do not have to be topped, but the trees will exist no matter what, where they are. And the trees are nowhere near the footprint of the buildings. And the idea of the tree protection is to actually protect trees within the footprint of a building. So that criteria does not apply. And in terms of neighboring properties' views of the ocean, he had acknowledged himself that there's really a wash in terms of view, whether it's within the existing setback or with the setback reduction. So I don't see how any of the criteria of 1764-010A4 have been met.
Nikki, you cited a chapter in 17, I think it's 6.4, that talked about our authority to impose
yes,
a geology report. Were you? I was.
So in the new code numbering, it's 17-108-030.
Would you mind? I'm sorry, I don't have it up here in my character. I'm reading that one more time.
So to orient everyone, this is chapter 17-108, which is development requirements for potential geologic hazard areas. So this applies to areas that are with an average slope of 20% or greater, where there's a potential landslide hazard, in areas abutting the ocean shore, or in areas that are identified by Clatsop County as containing weak foundation soils. We move to 17-108-030 procedure. It states that the requirements of this section shall be met prior to the issuance of a building permit. That makes sense. That's fine. We all understand that's the basic requirement. However, the next sentence reads, the city manager may require that the requirements of this section be met in conjunction with a request for the approval of a setback reduction. So it's in conjunction with your request or application for a setback reduction as opposed to after the setback reduction has been granted. My read of Mr. Burton's reference to the Luba case is that in that matter, wasn't here, but I am guessing the Planning Commission didn't feel it was necessary to see a geological report before making a determination on the setback reduction. To me, we are in a really interesting situation here because this property is right off of Hemlock Road, which, as we all know, is an artery in all senses of the word for the city. Karen Labonte brought this up last time. It is the one way that people north and south in Cannon Beach can get through. So in an emergency, that artery must remain open. It also must remain open even if there's utility work occurring. As I recall, our conversation with Mr. Burton from the last meeting was that we had some significant concerns about that hillside, and that if it were to be excavated, we didn't have any idea whether that would harm the stability of that slope, whether it would harm the potential for the utilities, not only water, but everything else that runs through Hemlock to remain contiguous and unharmed. That was why we had told Mr. Burton that we wanted to see geological report so that we would know and we would be able to assess whether he has met the burden of the criteria in 1764-010. It is not our burden to meet it, but it's his. And that's why we suggested to him in the effort to help him figure out what it would take to move this through, that he bring in a geological report.
Which is attached, but does not answer.
They specifically state they can't answer specifics because they don't have a final project. And of course, we have Mr. Taylor's application coming up later, in which it appears that there are some significant hazards in the neighboring property.
Yeah, it states that the assumption is that the strength of the wall is infinite.
Right.
Which is just an assumption. It is absolutely not true.
It's the only assumption that you absolutely know could not be true.
Absolutely.
I don't know how that affects their calculation.
Well, if you assume it's infinite, you have a whole set of calculations that are based on that wall being perfect.
Yeah.
I mean, it's, you can't work with that.
I just wanted to comment on the section numbers. Again, the reason why the section numbers are different was because the application was submitted prior to the reorg. So just so you guys are aware of that.
Kind of took it back to the comprehensive plan. There's a couple of aspects that I think are really relevant, and one of which is that the S curves are specifically held out as a hazard area, and there's specific language about the care that should be taken. I was also going to bring up that it's the comprehensive plan that also essentially dictates that there shall be no private access off of Hemlock. So I think that we're well within our responsibilities to protect those.
Is it time for motion?
Any further comment? Any further concerns?
Well, so I'd like to, at least just the only aspect that I really thought about was this lot of unusual configuration. And I think Mickey's already pretty well gotten ahead of me on that. But, I can clearly see that by moving the house further east, that the slope of the driveway could reasonably be reduced, but there doesn't appear to be any guidance from, any reputable source that says what is too big versus too small.
I looked up, just out of curiosity, I thought of the city of San Francisco, and I thought, those are some steep streets. People are entering and exiting. The steepest street in San Francisco that people live on is 37% slope. So I agree, 30% is steep, but people in the city are living at slopes even higher. So that's why even if Mr. Burton chose to use the most direct route to his garage, which he does not have to use, he has alternatives. Even if he chose to do that, it's not prohibitive. It's just not his preference.
In regards to the slope, we have to remember that average grade is based on four corners. Not having the setback reduction pushes the house further down the slope, which also reduces the floor level, which will also reduce the driveway elevation. I think you hit all points on it. One additional point of consideration is, as you stated, that section of Hemlock is a arterial street. For any instance that there has to be some public work done, whether it's there's a high pressure waistline there, 40 PSI. If that breaks, we still have to provide access along Hemlock. If there is a prohibited access, that means it's going to close off from basically Ross all the way to Golconda. And that's one of my big issues with this, is that Public Works will have to tell people that they cannot access their homes along Pacific and beyond, because there's only one route in and out of Pacific. So that's where I'm coming.
Further thoughts, consideration? Motion?
Yeah, I move that we reject the application for variance.
Is there a Any further discussion on that motion? Do I have a second?
Second.
Tessa, will you call the roll, please?
Commissioner Ostrander,
Oh, I'm sorry. Let's hold. Do we want to do a temporary? What's the plan?
Yeah. With the only question I would have is whether or not you are comfortable with staff providing the findings and having the chairperson sign them, or if you want to make a tentative decision to deny and have staff draft findings to be brought back for the planning commission to consider. Either way, we're willing to do them and have the chairperson sign, but those are the options that you have available to you.
To modify your motion.
Yeah, I move that we tentatively deny the request for a variance. Until
And direct staff to draft findings
staff to direct findings.
for plan commission review.
Absolutely.
Okay.
Got a motion.
We got it.
Okay.
Absolutely.
Further discussion? No. Tessa, will you call the roll, please?
Commissioner Ostrander,
Yes.
Commissioner Moritz,
Yes.
Commissioner Matusik,
Yes.
Commissioner Bates.
Yes.
Commissioner Sinclair,
Yes.
Commissioner Orwell,
Yes.
Chair Newsom.
Yes. Is tentatively.
Can I make one comment on that real quick? That probably will require us to maybe set up a special Zoom meeting so that we can get moving. So we'll probably try to do that, I would say, in the next week or so. So I'll try to put some times and dates out there and let you know when we can get that done.
Next.
Could put in a pre-request on scheduling.
Yes.
If it's next week, I'm in hearing all week, so noon to 1 on any day is the best time for me. Or before 9 a.m. if anyone's an early riser.
I have an additional request, not Monday or Tuesday. I'm going to be traveling those 2 days, so I'm traveling back to Canyon Beach, so I won't be able to attend a Zoom meeting.
I appreciate that because that'll give us some time to draft them.
Okay.
I figured.
We're at an hour and a half and there is a letter in here that I've not read. Why don't we take a 5-minute break and resume our meeting at 7:30? Relative to this next item. Okay. Next item is also a quasi judicial hearing regarding public hearing of V 2406 to Gaddis. Forgive me if I got your name wrong. Requesting a variance, V 2406 Pamela Gaddis. Application for variance to lot coverage requirements in conjunction with alterations to an existing mixed building. Property is located 188 West Jackson Street, tax lot 2400, map 510 30 AD in a residential medium density zone. The application will be reviewed against the criteria of CBMC 17.90 variances. Does anyone object to the jurisdiction of the planning commission to hear this matter at this time? Does any commission member believe he or she has a conflict of interest or personal bias? Any commission member had any ex parte contact?
Ex parte contact. I was contacted by the applicant in January 2024. I met in person, reviewed her project, informed her that this was going to be a difficult process for her to go through and a process that she would need to do. The applicant felt that she has been unfairly persecuted by the city of Cannon Beach in previous times. I had to feel it for her, but I did not hold any specific opinion of the project itself. I spoke to Mike Morgan, who was going to represent the applicant, and explained to him that my time and availability and the conditions of the situation that I could not take the project on. I informed the applicant June 24 that I would not be able to help her in any way. I received no compensation at any time. I do not feel that I have any bias for or against this applicant or the application. I will take into consideration any response from our city attorney and our city planning commission members.
Bill, did you hear that? So Bill, there, I have a little bit of concern based on what Mr. Commissioner Orloff just stated. I'd like your opinion on whether we have I don't even know if it's a conflict, but potentially jeopardizing any decision we have here tonight.
So as I heard it, and I apologize, I had a little bit of an unstable internet connection while Mr. Orloff disclosed that information.
It's pretty important. Will you state that again, especially around just everything you said, please?
I'll do the best I can to repeat it. I was contacted by the applicant in January 2024, met in person. I informed the applicant that of the process that would need to be going through to try to get this through due to the conditions of the issue. I did also speak to Mike Morgan and explain to him that the time and availability and the situation that I chose not to take it on. I informed the applicant in June 24 that I would not be able to help her in any way. I received no compensation at any time, and I have no bias for or against the applicant or this application, but I will take into consideration the consultant of the city attorney and my fellow planning commission members.
Thank you.
All right. So the three areas of concern are always, bias, conflict of interest, and ex parte conduct. The bias is almost always internal. Can you, based on the information you have in front of you, make your decision based solely on the record and the evidence, or only on the city code and the evidence in the record? There have been a number of cases that have gone to LUBA in the Court of Appeals, and it's a very high bar to be biased, as we've discussed it at several times. Absent some indication where Mr. Orloff has indicated that, I believe this is a silly code section and would never enforce it or something similar. It's, the bias is really in the members, internally. Can they make that representation? The second issue is conflict of interest, and conflict of interest, as you know, is fairly narrowly defined under Oregon law to be a financial benefit or detriment. From what I heard, he has received nothing and will receive nothing whether this vote is approved or denied. It doesn't sound like there's a conflict of interest. The final issue is really ex parte contacts. Ex parte contacts are not necessarily illegal. The critical piece with ex parte contact is any information that a commissioner receives needs to be disclosed in the meeting so that all the participants can know what you're going to base your decision on. And so, they have an opportunity to rebut it. For example, if you were to say, well, I actually went out there with a measuring, tape and found out that it's 6 feet high, not 3 feet high, and that changes things in some way, then, that would be an ex parte contact where you have information that's not part of the record that nobody else has an opportunity to rebut. So, in the case of an ex parte contact, the obligation is not to not participate. It is to disclose that information so that all parties are aware of it. So that's the background that we're dealing with. In terms of bias, as I said, that's entirely up to the planning commissioner unless there's extrinsic evidence that indicate that that bias isn't there. In terms of conflict of interest, again, unless there's some other information about the planning commissioner's remuneration in some way, it doesn't sound like there's a conflict of interest. And the ex parte obligation is to disclose. Certainly, a planning commissioner who believes that their impartiality might be questioned has the ability to recuse themselves and say, you know what, I'm going to step away. But that is, from what I've heard tonight, that doesn't sound like the obligation is there.
One thing that I'd like to add is that I did do a public records request on the property, but I found nothing that could be used for or against this application.
Bill, there are a couple of opportunities for us to discuss this situation. We can do it now, body. We can leave it open and allow the applicant or their representatives to make, and or leave it open for the applicant to make their comments on as to how they feel about it and then rule on it? At what point should we make that determination, or should we leave that open until, before we close the public testimony part?
To a certain extent, there's an ongoing obligation, you know, you can have that discussion now. And if in fact, during the course of the proceeding, you know, the applicant comes up and said, well, actually, you know, we had this conversation, or an opponent says, you know, here's a letter I got, you know, so that can arise at any time. But based on the information you have now, you can make your determination, you know, currently, or wait to see if anything else comes out in the public testimony.
This is the closest one.
That's it.
This is a tight one. And I don't know, I think the easiest answer is to recuse yourself. That's my gut on this.
Okay.
I don't know that. That's my opinion.
If that's the opinion of the board, I would respect that.
Other thoughts? That's just me. I'm not speaking for us all.
Where do you think the conflict is?
The statement that was made about the opinion on the city. The city being out. I've forgotten how you worded it. I almost don't want to hear it. Because I think it potentially tips on bias.
Even though that was the opinion of the applicant, not my own.
It was her opinion with outside of this body. And you being on this body now creates what I would consider a conflict on that very statement.
Okay. Well, then
I'm not speaking for the group. That is my opinion.
I don't think I feel as strongly as you do, but I think from maybe even the applicant's standpoint, it may be easier if it doesn't feel as though you're in a position to make a decision one way or the other. So I actually think there may be a comfort level there that just, I don't think it's strictly necessary, but I could see it being good governance.
Other thoughts?
I'm kind of with Mickey on this. I'm having trouble seeing the connection, but I also believe that we need to stay squeaky clean so we can't be questioned. And if there's even the appearance, Jay, I think, at that point.
Mike, I know you've had to make the same decision at one point in time.
Well, I made it the right way, so you make it the right way.
And I respect you for that, and I will recuse myself from any deliberation or decision on this applicant.
Okay.
Thank you.
With that in mind, what you'll do is you can take a time out here really for a little bit. I think we'll be talking about this while here, but you sit up. Thank you, Mr. Rob. Okay, we'll move to the staff report.
Thank you. Be just a moment. I'll bring a document up. The application is for an after-the-fact review of exterior alterations for a mixed-use structure consisting of one residential unit and two hotel units. The property is zoned residential medium density R2, and the mixed use is a nonconformity. On October 20th, 2023, the city of Cannon Beach issued a violation notice regarding structural alterations for which a building permit has not been issued. The alterations include the enclosure of both upper and lower decks of the western facade of the residential portion of the structure and conversion of those areas into the habitable space. The image on the screen shows the structure prior to work, and this image shows the structure at current conditions.
Do you mind just scrolling back to the other one for a minute, just so I get it? Okay, thanks. Thank you.
Version habitable space. As this is a mixed-use building, structural alterations require review and approval by the design review board. Board approved file DRB number 24-20 during its August 2024 public meeting. And a condition of approval is that the applicant obtain a variance to lot coverage requirements prior to issuance of a building permit. As the calculated lot coverage is approximately 62%, and the residential medium density R2 zone limits lot coverage to 50%. The applicable criteria from chapter 17.90 variances, the staff comment is that prior to the start of work, The structure was a nonconformity regarding its overall lot coverage. I'm going to skip a little bit here about a schematic that is included in the staff report. And the work performed by the applicant does not appear to have increased the amount of lot coverage. However, the floor area ratio was increased somewhat through the conversion of the decks into habitable spaces. Although the overall amount of lot coverage did not increase, variance is required as a lot coverage nonconformity existed prior to the start of work. And that concludes the staff report.
Let's see, we have a piece of additional correspondence that was submitted late from Carrie Dozier. Has everyone had a chance to read that?
Yes, thanks.
Yes, okay. And is there any additional correspondence beyond that? Okay. Call for public testimony. The pertinent criteria to be considered are noted in the staff reports and listed on the criteria sheets in the meeting page of the city's website. Testimony, arguments, and evidence must be directed to those criteria or other criteria in the comprehensive plan or municipal code which the person testifying believes apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal based on that issue. Prior to the conclusion of the initial evidentiary hearing, any participant may request an opportunity to present additional testimony, arguments, or evidence regarding the application. The Planning Commission shall grant such requests by continuing the public hearing or leaving the record open for additional written testimony, arguments, or evidence. Persons who testify shall first receive recognition from the chair, state their full name and mailing address, and if appearing in a representative capacity, identify whom they represent. Is there a presentation by the applicant?
Chair and members of the commission, thank you very much. I'm Mike Morgan, PO Box 132, Cannon Beach. With regard to Mr. Orloff, I had no objection to him participating. I understand that he recused himself based on an abundance of caution, but I did have a long conversation. I don't know if it was long, but I had a conversation with Jay when I was asked to look into this, and he gave me a lot of good information. And I think he'd also had a number of discussions with Pamela, but anyway, that's I just want to say that for the record. So, my view of the issue, and I stated this at the design review board meeting, is that the basic issue is not the fact that they got into the building process without permits. I mean, that was a mistake. And as our former president, Richard Nixon, said, mistakes were made. And so I would hope that the Planning Commission would focus on the fact that it's, the variance criteria is what we're looking at. And the interesting thing, just to start out, the interesting thing about the building itself, there are two interesting things. Number one is if the building was 1 inch apart from the motel units, they never would have, it wouldn't be considered a multi-use building because it is their home and residential, single-family homes, as you know, don't have to go through the design review process. So we wouldn't have had to go through design review. Secondly, when the house was built in 27 years ago, at that time, the lot coverage ratio was 0.5, and the building as approved by the planning department and the building official was 0.62. And the Geddeses have not increased at all the lot coverage, and certainly not the FAR. Floor area ratio is well within the allowable limit. But the 0.62 was approved in 27. When was 27 from 24 is back in the 90s when the house was built. So I think that's a significant thing to think about. The design review board felt that they got into a discussion about the permitting. Why wasn't a permit applied for? Why would you do this? And I see that the commenters from the neighborhood have asked the same question. Why did this go forward without permits? Well, it's just that they didn't. But that's not our focus tonight. So I would think that the fact that they have increased the usability of the space by enclosing outside decks is the important note, the important aspect of it. There was a lot of rot. They like to do things by themselves, and are good at it. But they, once they started getting into repairing the rot, it was apparent that there was the opportunity to bring the western walls of the building forward, and that's what they did. And when I talked to Jay, he pointed out that it was something of a mess, and that perhaps I could help them sort it through. They are they have at this point applied for the design review board approval, and they got it. They got a design review board approval unanimously. It's a unanimous vote, and they are in the process of applying for a building permit. They have a quite extensive structural report from a structural engineer that lays out the fact that the front walls of the building. Can you put those up, Robert? The front walls of the building are consistent with code requirements in terms of structure. So in talking with staff, with Steve and Robert, the only reason that a variance is required here is not because the lot coverage has been increased. It's because the intensity of use has increased. In other words, instead of an outdoor area on the decks, it's now enclosed within the house itself. But the impact on the neighborhood is, in my view, very positive as to much. I think it's a very attractive design. And even Mr. Berlotti in his comments stated that he thought that the structure was very attractive. Because I think the construction work looks good and fits into the neighborhood. But he goes on to complain about the fact that it's an after the fact application. But once again, I don't think that that's relevant to your decision, and it wasn't relevant to the DRB decision. But I think the Geddeses are trying to do the right thing, albeit after the fact, and I think it should be they should be allowed to continue the interior. I mean, the exterior is all complete with shingles and the window walls, doors, and it's just the interior still unfinished, which is it was left unfinished so that the structural engineer could see see how the structure is put together. And as I said, he has approved the structural aspect. So I'm sure you know that if the variance is denied, the impact, it would be possible to move the walls back, but what would be the practical point of that, other than to be, in my view, punitive? Because I think they've done, they've enhanced the building. They've increased the amount of interior livable space, not by very much, and they've made the building more attractive for the neighborhood. So that's my humble opinion, and I don't know if Pam or Steve want to say anything.
Okay.
Yeah, I mean, when we started out, the happened is that started getting water inside of the house, and I had people look at it and said, well, this has got to be fixed. And as we tore it apart, instead of just a little bit, it ended up being the whole width of the house was all rotted out. Behind the sheetrock, all the timbers were rotted out. You couldn't tell from the inside. It was just a little bit of mold appearing, and we ended up, just getting further and further and further and further. And then we had to go, okay, well, what do we do about this? We're going to have to fix it. And I did the work myself. I had a couple of friends of mine help me. We didn't hire a contractor, because to me, it was a pretty simple deal that, you just build a little bit stronger than it was before and build it better than it was before. And I felt that since we weren't extending the foundation out, that we weren't taking up any more room. All we were doing is trying to protect it from future damage. And I mean, it was already real extensive. That's what was the purpose. And then, it just kind of, and I didn't feel that we needed a permit at that point. I'm not an expert on it. I thought, hey, we're fixing the damage, we're making it better. Might as well prevent it from happening again by, putting these doors here instead of back there. And so, I mean, that's where we were at. We weren't trying to avoid anything. I'm not a builder, I'm not a contractor, I'm just a handyman. And I've only been doing that for a few years, but I'm just kind of learning as I'm going, and that's about all.
Would you mind telling us your name?
Yeah, Steve Gaddis.
Thank you. I wasn't sure.
Yeah.
Question for Mr. Morgan, or maybe it's for Steve too. It mentions in the report that the non-conformance isn't increased at all from 62%. I was confused by that comment. I felt like that you know, they had a patio that was under 30 inches that wasn't included in lot coverage. So actually they did increase lot coverage.
They built over, from our understanding, they basically enclosed their existing patio, so the overall footprint didn't, to our understanding, increase.
But the lot coverage as it's defined did.
Well. Yeah, I'll leave that to you guys to comment on.
Well, I mean, I just want to get it comfortable.
Yeah. If you
Yeah,
don't mind.
go for it.
You know, when you take a look, would you be able to maybe bring up the pictures? Just from the standpoint of when you take a look at the old compared to the existing, you can see from the old picture, it kind of has the same, footprint in terms of they're not really coming past that lower roof portion. And so when you go to the new portion, you can see that the old roof that covered the patio has that second floor deck. And so they just pushed the deck out to that. So we felt from a coverage perspective that because that roof was over the patio previously, that coverage wasn't changing.
Yeah, it's interesting. I was just working through the definitions and I'll admit they're difficult, right? Will you go back to the picture? This area is not included in lot coverage calculations under this article.
It is.
It's not by our definitions. Our definitions exclude patios under 30 inches and they exclude anything under an overhang.
Well, it is included. There is a portion, every property gets sort of an allowance where you effectively divide the lot size in half and then multiply that by a quarter of the square footage of the lot. But generally speaking, that will only apply to things that are under 30 inches, and I do not.
Yeah, this is under 30 inches, so it wouldn't go.
But the entirety of everything under 30 inches doesn't just disappear from calculation. So patio, sidewalks, that anything above that allowance amount does get included.
Yeah, there's can you pull up the definition of lot coverage? Do you have it there?
Why don't we come back to this? I think just from
I just want to get clarity on it.
I think we should, but maybe.
Okay, it's up to you.
Okay, sure. Hold that thought. Any other questions for the?
No.
No, okay.
And I would like to point out that there's a calculation of the FAR, the floor area ratio, which is takes into account the little hotel units as well as the house itself, and is well within the FAR 60.60.
I'll put, I'm still kind of thinking about this and we could come back to it later, but I'll put it out there now and we may come back to it after we have a chance to hear from you. You said a couple of times, Mike, and I can understand why you would say it is not in your purview tonight. And that was the order it should have or not.
And I'm sorry, I didn't mean to be aggressive about saying that. It's just I
didn't take it that way.
My understanding of the law is that, we are here to look at the variance criteria and not the permitting.
And I think if I were sitting where you are, I would say the exact same thing. Where I'm sitting right now, and I'm not saying that this will be the opinion of this body, is we're the body that's responsible for the code in the city, setting the code at some level, making sure it's enforced. And it is on my mind that this could set an awful precedent in our city relative to the code that we put together. To start going, well, if you don't agree with it, you can come back and just do it and we won't even consider that you didn't do that. I don't know where that conversation goes, but I don't want to have it without you having a chance to respond. Mr. Geddes, I appreciate the backstory on how you got to the position of building this without a permit. It was on my mind, so thank you for offering that up. That's helpful. without that sort of testimony, our minds can go. We've had, any number of applications that have come before us, and some people have been very direct about what's happened and some people haven't, and it leaves us in a gray area. And we just, unfortunately, sometimes we go to the worst possible conclusion about what someone's intent was. So I do want to put out that I think we probably are going to talk about the fact that a permit wasn't applied for, and ultimately that may be the hardship that we're talking about, but we can't consider that the hardship. What I've been presented so far is the hardship, the weather damage. Well, the outside of that building as newly constructed could also get rot like every other building on the coast. I'm struggling to see that as the hardship, and that's one of the 4 criteria for me. So I want you to have the opportunity to discuss that concern before we close the record, and I bring it up.
Mr. Chairman, I think the issue of whether or not it sets a precedent is that always comes up in my experience. It's always brought up. Are we doing this? Is it going to set a precedent with every planning commission decision? And I think you might ask Bill Gavison. My understanding of the law is that every decision stands on its own. You're not creating law like the Supreme Court by making a decision that will affect future decisions, because a permit was not applied for or some other aspect. Every decision stands on its own is always been my mantra to planning commissions. And I don't know if Bill wants to chime in here, but I think it's a fair question. The hardship, I know the hardship is always it's a hard hurdle to overcome. Variances, typically are always hung up on what the definition of is. But I think the Geddeses have said that they are, they tried to make the building better. They started digging into the building. They found out that after 27 years there was rot and mold, and they could have left the wall at that same location, but they through their misunderstanding of the law pushed it forward a few feet, I think 8 feet. And I just think it's a reasonable request.
Mr. Geddes, you mentioned that some friends helped you. Were any of those friends licensed contractors?
No.
Okay. Thank you.
No, there's just, some guys I met that knew how to swing a hammer and, had worked for other people, but they were not licensed. They weren't contracted or anything else. And I didn't, knowing how long it takes to get something, the builders around here, from what I understand, most of them are, way backed up. We have to live there. I have to fix it like right now. I mean, we can't live in a moldy house with water pouring through the ceiling. So I just started tearing it apart, and then that's how it happened. And
okay, thank you. Any other questions for the applicant? Okay. Are there other proponents who would like to come forward at this time? Are there opponents who would like to speak? Please come forward.
Bertolotti, I live at 171 West Monroe. I'm gonna grab my water here and this is my voice. 17 West Monroe, P.O. Box 1382, Gannett Beach, Oregon. And we wouldn't be here tonight if these owners, I don't know them. My property abuts their property. I don't know them, have no bones to pick with them. But we wouldn't be here if they followed the rules. And that's to me, that's the bottom line. They've been before the planning commission before. It said in my letter to you several times, based on my conversation with Robert St. Clair, he did a record search. So they know that the planning commission exists. They've lived here a long time. They know that you have to get a permit to do work. They added 409 square feet to their house without a permit, without talking to anybody at the city. Everybody knows that you can't do that in Cannon Beach. And when I look at the criteria, the 17, let me see what, let me grab. See what I can. When I look at the criteria, they had no hardship. People have roof leaks in Cannon Beach all the time. We've had a roof leak. We hired Costa Construction and we've hired licensed contractors to fix the repairs. It's not that hard to do. There's no exceptional or extraordinary circumstances with that lot. It's a flat lot. It's a regular house. Number 3A3, your criteria, they meet that criteria. A4, I don't see where the granting the variance does anything specifically to the comprehensive plan. And the request of the owners covering more than the lot is allowed. The lot coverage conformity existed when the owners completed the construction of the house in 1997, 98. So that didn't change. And I guess my concern is that these people have done unpermitted work and they're just kind of insulting to all the people who live in Cannon Beach who follow them. And that's what I think they should have to do. They should have to follow the rules.
Thank you. Are there additional opponents to this application that would like to come forward? You really online, Robert? Would the applicant like to respond to anything they've heard at this time?
Well, again, I think, as Richard said in his letter, this, it's a nice looking building. And maybe that doesn't mean anything to the commission. It did mean something to the design review board. And that's why they approved it unanimously. But his whole argument is based on the fact that, that they didn't apply for a permit. And if that, I'm not sure that you want to deny the variance on the basis of the fact that they didn't apply for a permit for the construction. And they have applied for the permit for the DRB. They've applied for a permit from the planning commission, and they will go through the building department to correct that. So I think that's where it stands, and I think they should be allowed to go forward.
One thing that Mr. Berlotti brought up in 1790.030 A is those 4 criteria that all have to be met, but then B, variances in accordance with this section should not ordinarily be granted if special circumstances on which the applicant relies are a result of the actions of the applicant owner or previous owners. So the house needs this variance because of actions that were taken by the previous owners or current owners. Do you want to touch on that one? Because that one resonates for me.
Well, I might say that you need to look back 27 years to when the house was originally constructed, and the lot coverage at that time was 0.62. It wasn't, it wasn't 0.5. It was approved at 0.62. And they have not increased the lot coverage by pushing those two walls forward for the deck. So, Steve, the planning, community development director told me that the only reason or their rationale for requiring a variance is that the intensity of use is increased by pushing the walls forward and enclosing it into interior space. But, a lot of people use the outside decks just like part of their living space. But, the interpretation is that the intensity of use by pushing the walls to the west is the reason for requiring a variance. And I don't necessarily agree with that, but I respect the community development director's opinion, and that's why we're going forward with this. But it's kind of a knife's edge interpretation on from my view.
I would like to add something if I may.
Of course.
Emily Gavlis. One of the reasons that we also, that it basically, everything was covered, top was covered, it's just like, and they were rafters holding at the end of the covered thing. So basically it was like putting sliders in where it was already all covered. That area was already there, but the reason that we decided to do this, to have the extra space also and do the repair this way, we were told the way that it was built before, there were a lot of problems back in those years where the water would come right through the rafters all the way down from the top to the bottom. There was no separation. It wasn't built separate. It was a continuation. And so those walls couldn't be built the same way. The other reason was we had 2 of our grandchildren come to live with us as well, and through foster care, as young teenagers, one with special needs who's still with us, and will be and is an active member in the community and doing great, but that made more room in our home for livability, light, just everything that made the home livable. This is our full-time home. We're there every day. It's not a vacation home for us. We live there. So that was one of the main reasons we did that as well, to help with our family situation as it had changed.
One thing too is that, the whole time I was there working on it, I didn't know that I needed a permit just to enclose, because I knew that if you extend the foundation out, then that's a different story. The whole time I was working on it, not one person came by and said, hey, did you get a permit or you need a permit to do that or anything? And I know all the neighbors, I talk to them all the time, and they said, what are you doing? And I said, well, I got this leak. And they go, oh yeah, that's probably a good thing to enclose it if it's, leaking, and that's a good thing you're fixing it and everything. Nobody came by and said anything about it. So, and I never thought any different than what I was doing. It wasn't that somebody came by and said, hey, you need to get a permit to do this. I would have said, oh, well, maybe I better go check on that. I didn't know any better.
We have been to the city for other permits that we've needed to get, and
Sure,
have gone through that process.
Everything that we've ever done that I felt was something that the city needed to okay, or that we even thought that needed okay, we've always gone through here for everything.
We have 2 small businesses that we're extremely hands-on, and the only way we can keep those businesses afloat, we can't hire out to Coaster Construction. We're a very small business. We do the work. We do.
I do 99% of the maintenance on all of our properties, whether it's sheetrock or electrical or plumbing or landscaping or painting or anything. I do it all.
What other permits have you applied for with the city?
One of them was trying to get a permit to place hot tubs on the properties. And one of the neighbors didn't want hot tubs next to her house. And so it came before the committee.
But backing up a little bit, when we came to the city and said we want to put hot tubs in, they said, well, you have to get a permit and get, licensed contractor to run the 220 and everything. And we did everything and hired people to run the 220 out there. Well, got everything ready to go. And then when we got ready to set the hot tubs there, the guy who's in charge of the city looked through the books. He says, we have nothing in here about hot tubs, so we have to call it something different. We have to call it a deck. I said, it's not a deck. He says, we have no laws against what you're trying to do, so we're going to have to kind of make something up. And then when we came in here, one of the neighbors that she's been an issue, but she said, well, you can't have a hot tub because it's going to put chlorine into the water table. They were saltwater tubs. They weren't chlorine tubs. So she went over and got another neighbor that's like 200 feet away to say that if we put a hot tub in there, it would create noise, that he couldn't sleep, and that it was going to bring criminal activity to the town if we had hot tubs in there, even though we'd planned on putting signs that says, no kids, no alcohol, nobody past 10 or anything like that. So we spent thousands and thousands of dollars getting it all ready. And then after many trips in here, we were told you can't put them in. And it was, at the time, the design review committee said, well, what color are you going to paint the outside? They're the portable ones they just set in there. They're portable. They weren't permanent. They said, well, we don't like the color gray on the hot tub. Well, everything's gray here. And I said, what color is the inside of the hot tub going to be? I said, well, it's going to be covered most of the time, but we can make it any color you want. And, after paying to come in here, $200 per property per time, we just gave up and just, said, we're not going to do it because we didn't want to have to go spend another $5,000 to go to the LUBA. And when they were just probably going to kick it back here anyway. So, that was a kind of a tough experience.
Put the hot tubs in.
We just didn't even do it.
That was one of them. And I think that you have a list of some of the other that we have been in for.
But we've always conformed with everything that we knew was required. I was just I didn't know on this. So it wasn't like that we were trying to do something without permits. I didn't know it was needed, and nobody ever said anything that it was needed. I think if, maybe if I went to somebody like Coaster Construction or something like that, then they might have informed me, oh, you need this first. Then I would have said, oh, okay, I'll go down and get it. I didn't know. I just do all the work myself. If I have to replace something, I fix it. I'm not that good at it, but
I'm curious how many other properties you have that have issues like this, that you've extended walls by several feet and didn't obtain any permits.
Absolutely zero. I've never had this problem before. I've never had.
Yeah, it's never a problem until you get caught.
Well, I've never run across this issue before. Most of the stuff is just simple little stuff, and like replacing doors or replacing windows or something like that.
I hope that helps to explain why we did the project, why we undertook the project. Cannon Beach does mean a lot. This is my home. This is where I plan to live for the rest of my life.
And we appreciate you raising good kids, but having foster kids is not an excuse for extending your house by 400 square feet without a permit.
Okay, that wasn't the basic reason, but I was trying
that's what your wife said.
Keep the weather out.
That was a bonus to having the space for the children also.
I would like to limit our questions to the applicant to specific items around, as much as we can, around the request for the variance and any specific issue around the permit we could do as well. But let's try not to have this be too much of a cross-examination. Any further questions for the applicant? Okay, if there's nothing further, we'll close the public record and move to our consideration. Who'd like to start?
I had a comment to make about the variance and the total floor area, or not the floor area ratio, but the lot coverage. I was, oh shoot, I just lost the page. I was looking at the calculation that's in the packet for how the total square footage for what the lot coverage currently is, and what that it's at 0.62, which brought it out to I can't remember, I can't find the 4,654 feet of square footage that's part of the calculated lot coverage. That number didn't change. So from a practicality standpoint, I was just looking at this, they would have to reduce 904 square feet of the already existent building, not the addition, if I'm understanding that correct. If this were denied, is that correct?
No.
No.
I don't think so. How would that?
Well,
So the nine, if it's currently 904 square feet over the 0.5 lot coverage.
Pre-existing
I think,
use.
yeah,
So
Yeah.
this would require reopening the public hearing, but I could provide a kind of a rundown of how I did the calculations for this particular property. And
I think it may be a pre-existing use or non-conforming use question. So I think that if I understand correctly, Eric, you're asking, if we deny this, does that mean they need to bring their total lot coverage back down to 0.5? Or is it just that they have to remove the new enclosure? And so my understanding would be that if it's a pre-existing or non-conforming use, as long as it's not changed, it can remain non-conforming, but it's when it changes that they have to obtain a variance. Is that correct?
That's correct. I mean, basically what we'd be looking at is we wouldn't be saying that they would be denied the original footprint. It's just the enclosed aspect of the structure that would have to be removed back to the original condition, which was non-conforming in the first place, but it was the enclosure aspect and all of that. So the pad, the enclosures on the first floor and then the deck on the second floor would have to be removed back to its original condition.
Okay, so my confusion, I guess, of that is in the staff report, it's noted that on the north side of the property that it's within the setback, but that's not under consideration because that's not changed. But the lot coverage is also not changed. So that's, I guess where my confusion is, if the setback, if it doesn't require a setback reduction variance, why does it require lot coverage variance?
So really what we're talking about is lot coverage is there because it's over, but where it comes into play is that this is a non-conforming structure. And because it's not meeting the lot coverage, it's at that 0.62. And the ordinance states that a structure devoted to a non-conforming use may not be enlarged, expanded, or reconstructed. So the use is being expanded, enlarged from the deck to an enclosed use or a new room, basically, of the house. So they've increased the intensity of the use of the pre-existing non-conforming structure.
Okay, and then how is that separate from the setback?
Setback, I don't believe comes into play at all in this. They're not touching anything on that side of the structure. So that's that would be a non-conforming structure, but they're not doing anything to that. The area that was worked upon isn't creating any type of additional setback. variances or things like that. And because the existing spaces are already non-conforming, they're not touching those, so those can just exist as is, like any non-conforming structure. That doesn't make sense?
No, that makes sense. I just don't, I was just trying to figure out, I get what you're saying with, there's an adjustment in the type of use for the lot coverage. But I don't, I guess it's a moot point in general, because we're here with the application now, but I was just, I didn't see the difference between the setback reduction, no change in the setback reduction, and the lot coverage, no change in the lot coverage. There is a change in use, but not a change in the actual lot coverage itself.
That's correct.
Yeah.
I disagree with that. But there is this provision in here too. It says a non-conforming structure may be enlarged in a way that does not increase the non-conformity. We can talk about that, provided the total building coverage does not exceed 40%. So, you know, by the terms of non-conforming structures, they needed to come in anyway.
That's correct.
And
that's why it's here.
In here.
Yeah.
Others?
Yeah, I don't want to be punitive here, but, and I accept Mr. Morgan's comment about precedence, but, you know, I disagree with it. I honestly think if somebody, I mean, it's great. These guys did an improvement. It makes their house more functional. It was done well. So the implication is, if I understand the argument, we should just say, hey, so the next person that does it, what are we going to say to them? And the next person after that, because all of a sudden we've lost control of code.
May I say
Oh,
one
ma'am.
No.
also?
Sorry.
Or is it too late?
It's
Oh, I'm
closed.
sorry.
Sorry.
So that bothers me, but I don't want to be punitive, but then I go in and I can argue over lot coverage in the definition. And then I look at the terms for non-conforming uses and everything else here. And it's clear we should have a permit, and that's exactly what this is about. I mean, the question is, are we going to grant one after the fact?
Well, I think that's partially the question.
Also, does it meet the criteria for a variance?
Yeah.
We're here considering, does it meet the criteria for a variance? And we haven't even gotten there. Maybe we need to start there and then say, does it matter that construction has been done? Because the real question is, does it qualify for a variance? If it doesn't, it doesn't.
And there's that provision that you read. It says if it's caused by the applicant, then it shouldn't ordinarily be reason for a variance.
Is part of our struggle the fact that my belief is that we are not a body that should be exacting punitive actions. Our role is different. Much like the DRB's role wasn't to be punitive, they have their thing and we have ours. But I think in this case, I need to be assured, and maybe the people who have written in opposition need to be assured that there actually is an enforcement part of this, and the city's got that ability, but it's not detailed in anything we've been presented. You know, all I see is that they were given a written warning at some point last year. You know, there's no talk about are there going to be any penalties? There are certainly penalties in the code, at least the possibility of them. But nobody's talking about that. It's not I don't think it's our place to exact punishment. But the city, I think, does have some responsibility.
That's why it's here in the first place, is that we administered it. We tried to work with them. We gave them many opportunities to talk to different people to get to this point in time. Unfortunately, we worked with them. We probably should have pressed them a little sooner to get here. They had different contractors. If something was to be granted, when permits would be issued, if that was something that was to occur, yes, there would be penalty fees assessed for doing work prior to obtaining building permits. So the answer to the question is, yes, we have done things, and yes, we will, depending on what direction this goes.
You just said they had different contractors. What?
There was, the initial letter went out. I worked with the Gaddises as far as hey, we have someone in line. So it's like, okay, here are the dates that you need to meet to get your information in. That contractor went away. They asked for a little bit more time. Again, maybe I should have had been working on the enforcement side earlier. They had another contractor and finally it got to the point in time where I was like, okay, guys, we've been, it's been too long. Something has to happen. They got the application in, it's here today. So there were other people that they spoke to try to get an application in that didn't get the information that we needed. And then people changed on their end.
I'm not suggesting we be punitive either. The question is, do we accept deny the variance or not? That's it. I don't know what happened.
Yeah, I just, and I agree. I think it's important that there is an enforcement understanding of some kind, because that's really the piece that's missing.
Yeah.
I mean, I think there's a desire on some people's part for us to in some way be punitive.
Well,
And I don't want to do that. I don't think that's our role. Although I do think that the criteria that they have to meet is very clear, and I don't think that they've met it.
The challenge for me is I don't like the position either, but we're put in it. It was,
Right.
we've been
So
put in
what's
this.
the right, so what's the best thing to do?
Steve, right?
Yeah, so I think what the plan commission should be doing is taking a look at the application and the criteria as you would any variance application that's submitted to you. And then based on that decision, it is up to city staff to take the necessary steps in terms of enforcement and whether there's building permits that get issued if it was approved that would have penalty fees, or it's the issue of the enforcement of the actual removal and the timeframes required to get that done. And if those aren't met, what citations get issued at those times. So that's going to be on staff, ourselves and code enforcement to do that punitive aspect that you're speaking of.
And so that's what you were referring to earlier about whichever way this decision goes tells you whether it's removal or
correct
something. Okay, thank you.
By the way, I don't like the idea of us being punitive, but in looking at our code, the way it's written, we can make decisions based on protecting the comprehensive plan. And if the comprehensive plan has this set of goals that are adopted by the people through a public process, and that process is not followed, we do have that latitude. I'm not suggesting we use it, but I also don't believe it's fair enough. I think you had a good point, Mickey. Let's just
Yeah, let's start there.
Variance itself.
So I'm looking at one, that a strict or literal interpretation and enforcement of the specified requirement would result in practical unnecessary hardship, would be inconsistent with the objectives of the comprehensive plan. So I'm trying to picture what hardship this is referring to. In this case, is it saying the hardship of not being able to enclose that space? Like, is that imposing a hardship if the owners are not allowed to enclose that 400 square feet?
Well, to be fair, it does say practical difficulty or unnecessary hardship. So we have.
Yeah, so those two, but I'm assuming that means we're asking a criteria, they're asking us to apply the question. If the applicants weren't allowed to enclose that space, does that impose a practical difficulty on them or a hardship?
If the answer is it made our space more usable and we got more light and it helped with our kids.
My sense too.
Les?
Repeat what you said, Mike.
Oh, she was asking.
Was there a practical difficulty?
Yeah, or the practical difficulty.
Or unnecessary hardship.
And so so the question is, if it's just the extension, what was the hardship that existed? And I think they said they had water damage, which we've had, and I didn't blow out a wall and make my house bigger. And then they had the goal of making their house more usable, and that is not a hardship. That is a preference, but it's not a hardship. If it's, now if you're telling me I can't get a variance, and what does that require me to do? Then there's a provision in there that says that the hardship is caused by the applicant, and the variance ordinarily shouldn't be granted. So either way, I have a difficulty in finding hardship.
Anything you want to weigh in on this point? Okay.
Mr. Chair, I don't know if it's appropriate, but I think Gaddis's would like to request a continuance.
We've closed the record. I can talk to our attorney about that. Bill, are you hearing this?
I am, you have closed the record. You know, you can reopen it to hear additional requests, or you can, leave the hearing closed.
Okay, thank you. I mean, we're not bringing up anything new. I feel like if we're bringing up something we hadn't brought up before, I'd be more inclined to open it back up. Just how do people feel?
I don't think.
No, we're not going to open it back up. All right, let's move on to, well, okay, so all four of these criteria have to be met, and we haven't gotten through one.
Right.
Do you guys want to continue to talk through these other three?
No.
If it helps, I don't mind, but
it might help.
Yeah.
Okay, let's do it.
So are there exceptional or extraordinary circumstances or conditions applicable to this property involved or the intended use which do not apply generally to other properties in the zone? In my site visit from the street, I didn't see any difference between this property and the surrounding properties myself.
I think if you take a tree, the granting of the variance will not be detrimental to public health, safety, and welfare. I think you can make an argument that it will. If it destroys our variance procedures and just blows a hole in it, and people can go do what they want.
I think that's a little broad.
Well, I don't.
They may meet that criteria, and that's fine.
I think they do.
And then that the granting of the variance would support policies contained within the comprehensive plan. And I think this gets a little bit to your point, Clay. The comprehensive plan is about having a plan for the community that involves regulated development. So to me, granting this variance doesn't support that policy.
Thoughts? Aaron, Eric, any thoughts on the discussion so far?
I'm still kind of hung up on there's no change in the nonconformity of the structure. As Robert has calculated it in the application, that they had 0.62, they will continue to have 0.62 lot coverage. I'm still hung up on that, and what denying the application does for anything. And I completely agree. I don't think we should be a punitive body, like you guys were discussing just a few moments ago, but I don't know what the repercussions are for if this is approved, what repercussions that they receive in terms of having done all that work without having permits. Because if you had applied and then started doing work, you have all those fees that start piling up about work prior to approval and all that, but there wouldn't be any of those in this instance.
So it seemed clear to me that it's about the intensity of the use, not whether it's still 0.62 lot coverage. And that's why a permit was required. And that's why we're here talking about a variance. So it's not about did the building footprint change? It's about the fact that the intensity changed, required a permit, and because this was a non-conforming use, they have to have a variance to continue that non-conforming use if they are changing it in terms of, for instance, making new livable space. It's truly different than it was before. It's no longer an outdoor porch, it's indoor living space. So it's just how the code functions, which again it is what it is. And I think Jeff Adams used to say, you have the code that you have and you need to apply it. And I feel like that's what we're attempting to do here.
Yeah, and I agree with Mike Morgan's position that every variance should stand on its own. I mean, I wholly support that. I don't see how that helps him. I mean, his argument is a few feet, and then he goes on to say 8. Well, I mean, if it was a few feet, a foot or 2 or 3, maybe, but 8? I mean, I just can't get around that. So I don't see how, even if we look at every variance on its own, that we would have ever approved this.
Is there any other comment, or are we at the place where someone would like to make a motion?
Yeah, I'll make a motion. I move that we deny the application for variance.
Is this another one we should tentatively?
There's 2 ways. I'll say the same thing I said before. We can either direct staff to draft findings and bring them back, or have the plan commission allow the chairperson, allow staff to draft them and have the chairperson sign them. So we're open to either way.
We're already doing one findings meeting.
Yeah, let's do a
Let's do a tentative.
Tentative motion.
Sure. Tentative motion to deny the application.
I'll second.
A motion to tentatively deny.
It's that time of night.
Yeah. Further discussion? That's what we call the roll, please.
If that was Matusik, yes.
Commissioner Sinclair,
Yes.
Commissioner Ostrander,
Yes.
Commissioner Bates,
Yes.
Commissioner Moritz,
Yes.
Chair Newton.
Yes. Variance is tentatively denied. We're at 9. Anybody need a break? Oh, thank you, Jay.
Jay doesn't need a break.
He's ready to go.
Exactly.
Okay, we have another quasi judicial item before us, public hearing CU 2405. Piera, requesting a conditional use permit. Juan Piera of Viridian Architecture on behalf of Alexander Hayes application for use permit for construction of a privately owned campground. The property is an undeveloped parcel on Reservoir Road, tax lot 500, map 5102. In the original zone. The application will be reviewed against criteria CBMC 17.86 conditional uses. Does anyone object to the jurisdiction of the planning commission to hear this matter at this time? Does any commission member believe he or she has a conflict of interest or personal bias? Does any commission member have any ex parte? Can we have the staff report, please?
Excuse me, yes. The applicant requests a conditional use permit for a privately owned campground on an undeveloped parcel on Reservoir Road, east of the intersection of Sunset Boulevard and Highway 101. Application materials indicate that the proposed campground will consist of 10 to 15 tent-only campsites, a system of hiking trails, a check-in structure, shared bathroom, communal wiring, and a gravel parking area. Moving into the applicable criteria for the overlying zone, the open space recreational zone. The staff comment is that the application meets criteria A. which is a conditionally permissible use in this zoning classification, criteria A being privately owned campgrounds. Continuing on to chapter 1786, conditional uses, use standards. The staff comment is that the application narrative indicates that a demand for the proposed use exists as a result of the local tourism-oriented economy and a relatively low number of developed campgrounds within the city or its immediate vicinity. No specific information about potential traffic impacts is provided. The preliminary site plan, included as Exhibit B3, shows 11 campsites and a parking area with 13 spaces. The segment of Reservoir Road right-of-way connecting the subject property to the intersection with Sunset Boulevard measures approximately 585 feet, of which approximately 530 feet is minimally developed. It will be necessary for the applicant to develop Reservoir Road to a standard specification acceptable by the Public Works and Fire Departments for access by customer vehicles and firefighting equipment. At present, the subject property is not served by any infrastructure such as water, sewer, or stormwater. A 12-inch diameter asbestos concrete water main is present in the Reservoir Road right-of-way. This line connects the Sunset Boulevard pump station with the water storage reservoir to the southeast of the site. Map number 2 included in the staff report provides details about subsurface infrastructure. Excuse me. Annexation into the city will be necessary before public utilities can be extended to the subject property. At present, it is located within the urban growth boundary, but outside of city limits. Jurisdictional boundaries are shown on map number 1 included with the staff report. Proposed condition of approval number 1 will require annexation prior to the issuance of any development or building permits to allow the extension of utilities to the site. Significant slopes are present on the property with elevations ranging from approximately 120 to 180 feet above sea level as shown on map number 3. The applicant's preliminary site plan, which is excerpted in the staff report. Parking is planned to be located on the lower elevations with tent pads accessed by trails farther up the hillside. As this is a non-residential development, review and approval by the design review board would be required prior to the issuance of any development or building permits. And that concludes the staff report.
Okay, thank you. Is there any additional correspondence?
No.
Pertinent criteria to be considered noted in the city's staff reports and listed on the criteria sheets on the meeting page website. Testimony, arguments, and evidence must be directed toward those criteria or other criteria in the comprehensive plan and municipal code which the person testifying believes apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal based on that issue. Prior to the conclusion of the initial evidence you're hearing, any participant may request an opportunity to present additional testimony, arguments, or evidence regarding the application. The Planning Commission shall grant such requests by continuing the public hearing or leaving the record open for additional written testimony, arguments, or evidence. Persons who testify shall first receive recognition from the chair, state their full name and mailing address, and if appearing in a representative capacity, identify whom they represent. Their presentation by the applicant. You can publish.
Hi, my name is Juan Ferreira, P.O. Box 456, Nehalem, Oregon, 97131. I am a designer at Meridian Architecture LLC. We're based out of Nehalem, Oregon. Here with me is Jim Fanjoy. He's a principal and owner, as well as our clients, Alex Hayes and Sophia Knox. Wanted to first off, thank you all for the opportunity to speak. I'll keep this brief in order not to reiterate our application materials. We are thrilled to be working on this project with Alex and Sophia. We believe our clients, as well as our proposed developments intentions, are well aligned with the values of the Cannon Beach community. From the very first time we met with our clients to discuss the project, the main goal of their development has been consistent: to preserve the site's existing forested character to the greatest extent possible. This coastal forested character is what drew Alex and Sophia to Cannon Beach, what drew them to this particular property, and what they believe will draw the campground's future visitors. By developing the site according to this goal, we hope to ensure a mutually beneficial project that provides additional lodging to Cannon Beach's tourism economy, stewards the character of the forested site for the enjoyment of adjacent parcels and the community at large, and gives visitors to Cannon Beach a nature-centered camping experience only steps away from the heart of Cannon Beach. We thank you for your consideration and would be happy to try to answer any preliminary questions you might have.
Any questions?
I was just curious why you're calling this a preliminary site plan. It's hard for us sometimes to really get a sense for the project if we're just told, here's what it's going to look like someday in the future, and we don't have some assurances about whether the character of what's proposed is going to change. So I'm just letting you know that for me, that's one of my concerns, to see something called preliminary and not know that we approve something that balloons out into a very different project later. Just throwing that out there.
Can I address that?
Sure, please do. That's
Yeah, so I guess there's a kind of two parts to that. From the professionalism within architecture, we tend to put that on any drawing that's not a final construction document, just for clarity. And then the other part of that is that we will at some point bring consultants on board, an arborist. And so we just want to leave space for if there's a site that's conflicting with a tree. Again, the main goal of this is to maintain the character, save as much of this site as possible. So we just want to give ourselves room when we talk to this arborist. And if he tells us it's helpful to move this tent platform a little this way, a little that way, we just want to have room to be able to do that.
And these are tent platforms. You're not proposing a covered structure over the platform.
Correct. It's just the platform, and the visitors would bring their own tent and so.
You were informed of all the stuff that needs to be done before you can make this a reality, right? I mean,
Yes, sir.
why are you bringing this in now when you don't know that you can do all that other stuff? Is there a reason for that?
Yeah, I guess our goal up to this point has been to make sure that this project even has legs before we bring too many consultants on board, just in an efficiency for our clients. So we're just thinking, we got to the point where we thought we were ready for this application to bring this in front of you. I'm clearly open to this conversation, but that was our goal.
Right.
Les, did you have a question?
Well, I was just going to confirm, I don't think exactly say, but I believe that there's no utilities, no water, no power to any of the tent sites. They are truly natural. Is that correct?
Right. The tent sites would not have utilities to them. All utilities would come to kind of the shared space.
What is envisioned for the shared space? So is it, you say there's outdoor showers, I assume a set of stall bathrooms? What are we talking about in the way of developed?
Robert, are you able to?
Yeah.
Thank you.
So I see the outline on the map, but I'm just curious if you can describe for us.
Oh, yeah, totally. So what we're doing is off of Reservoir Road, all the parking is bundled together.
Okay.
So we're planning on providing one spot per tent platform, plus one spot for staff. Maybe two spots for staff is what we're showing right now. And then as far as actual structures, they're very small structures, about, I'd say, 8 by 10. So there would be one check-in stand, and that's where the employee would kind of check people in and out. There would be one shared bathroom, and that would be showers, toilets, sinks. And then there would be a communal fire ring, and that's what's kind of part of the shared space of all of this. And then south of that, which you can see from the map, there would be a system of permeable trails that would lead up to those tent platforms. And again, the trail is kind of drawn in a way to avoid the trees that we have on here right now. But again, that's part of what we would talk to an arborist moving forward to make sure that we're setting things up in the right place.
Do you have plans to speak with an arborist?
Yes.
In the near future?
Yes. So our goal was to get through this meeting, and then I know that we'll have to go through plan review. So our thought was that if we get a green light or we feel like this project has legs, we would then bring the whole team on board, and what we would present to the plan review would be like the full construction documents with our consultants.
Yeah, ordinarily, we would get a tree plan with this, wouldn't we?
There would be a lot more information provided so that you would have some better understanding as to what's being proposed.
So are you clear what's needed
Yeah, we've had conversations about what's needed. And again, I think our goal has just been to get to this point where we feel like the project is possible before we bring on all of those
I
consultants.
think it's possible, but I can't.
Yeah, go ahead.
We did have a pre-development meeting with Mr. Ferrera, Robert and I, Trevor from engineering. So there was a lot of information that was provided. You know, it was indicated that that you'd probably need a little bit more information than what you have before you in order of feeling comfortable to make a decision one way or the other. So the application was submitted and we processed it.
So 30 days though, would that be enough time for you to get some of the information that we would need?
If I were provided the information that was needed, if it were a tree plan, if it was geotech, believe so, depending on consultant schedules.
And Steve, what would you like to?
I would think we would have to be doing another pre-development meeting before an application was submitted to Plan Commission, because I think there's a lot of discussion that needs to happen with staff from the standpoint of feeling like the application's complete to bring it to you for consideration.
Okay. So can we identify that for?
Well, can we do that once we?
Why don't we run our process
Yeah.
and come back to that? Okay. Other questions for the?
Yeah, I have an additional question in regards to the pathways and the parking area. I assume your parking area is going to be some non-permeable surface such as asphalt. You've described a permeable surface for the pathways to the non-ADA campsites. What is your intent for the pathway of the ADA pathway? The quarter minus is not a useful surface for wheelchairs and such. Do you have any differentiation between the pathways, one to the ADA and one to the campsites themselves?
Yeah, I think our vision for the trails to the non-ADA campsites are very much like a hiking trail. It's just, the cut in the earth, it's soil, it's steps as needed. For the ADA, I'm not fully into the details of that, but we would consider like a paved path from so we put the ADA spot where we knew that we could get to without much of a climb. So the materiality, although we haven't picked it exactly right now, it would be something paved.
Yeah, so you're running along the topography.
Yeah.
Do you have any information that you can provide to us in regards to what the preliminary ideas for the structures for the outdoor shower and the check-in stand would look like?
It's not designed, but our thought is that it'll be cedar shingle, very simple, cedar trim, probably asphalt shingle roofs, very simple shed roofs is our assumption. And I guess just kind of a question to y'all, where I was sort of confused is exactly to what level of detail we wanted to get to right now. So I appreciate this conversation and I appreciate the guidance. Yeah, we have plans to continue to develop this. And again, we just wanted to make sure that the project had legs.
Okay. Other questions for the applicant?
Just one more question. That is a fairly steep hill. As it's already been noted. I guess I'm just wondering out loud, are there any geological geostability concerns that would be triggered by this kind of a development?
That again is something I think we'll talk to with the geotech. Our thought is that, with those being non-ADA and very simple, small tent platforms, that we could find a system that would kind of work with our site. But again, I think those details we were planning on including in our next application through plan review.
Any other questions? Okay, thank you very much. Is anything further?
No, that's it. Thank you.
Thank you. Are there presentations by proponents of this project? Okay. Move to presentations by opponents of this project. Okay, Any last words? We always end with the applicant having the.
Can I make a procedural comment?
Sure.
Right.
As you are part of the applicant.
Yeah, I'm on his team. It says proceed.
Give us your name, mailing address, and
My name's James Fanjoy. I live on Highway 53 outside of Nehalem, and I'm on the design team with Juan. And as a procedural point, I wanted to request that what we're looking for here today would be an approval. And I know that you may have additional questions in terms of geotechnical study and arborist reports. And might ask you consider making, if you wanted to have more additional information for the geotechnical report and the arborist study, you could make those a condition of approval if those are the only things that are standing in the way in terms of technical information, in that our project wouldn't be approved if we didn't provide a satisfactory geotechnical proof that the geotechnical capacity was there and that the arborist results were okay. Just wanted to add that as a procedural thing. Thanks.
Before we close the record, any comments to that? No? Okay, then we will now close the public testimony portion of our consideration and move to our deliberation. Who would like to start? Okay.
I think it's a very limited use in the zone, and this falls within the uses permitted. It's a rather non-invasive use, but I do feel that we need additional information, specifically on the arborist, number of trees being taken down, location of those trees being taken down. As for the geological portion of it, although it's a slope site, we're not talking about very heavy structures. We're talking about decks. We're talking about pathways. The tent structures could be supported by a product called Diamond Pier, which is a non-invasive point load system. I don't think, other than the parking lot itself and possibly the grading to the ADA accessible site, would be of a geological interest to me. But beyond that, I mean, this project excites me. I think it's a good use of this place.
How are other people feeling?
I agree with Jay on the project. I'd like to support it. I'd like to see some more information. I won't get ahead of everybody, but I think I'm leaning toward a continuance and then deciding, I'd like to see a tree plant, at least. That's usually what we get. And it looks like there's some clearance there, clearing at the parking lot. So I'd like to know what's going on. I do understand why they're coming to us now.
Sure.
Because there's going to be a major investment for the development of Reservoir Road, not only in the road itself, but the utilities that are going to be. But
I actually, sorry, Jay, I didn't mean to interrupt you.
No, please go ahead.
I actually had a comment on the same lines that I feel there's in one of the email correspondence that was included in the packet, that it feels a little cart before the horse with getting utilities to the site, and that annexation of the property looking like it's likely going to take longer than what an approval here would permit. Like the timeframes just didn't. I think I read it that there's an expectation that if they were to seek an annexation, that it would take longer than it would take over a year for that process to go through. Is that what I understood from the email correspondence between Steve and the applicant?
I don't know exactly if it's a year, but it's something that, they would have to hire someone to get it in. And there's no question that's at a very minimum, probably like a 3-4 month, if not longer process. And what the concern is with some of the approvals is that a conditional use permit's good for a year. So there's some timing elements to, that the applicant just knows that that's out there, and the cost of the infrastructure, the cost of the road specs. There's some significant costs in here that I believe are very important for the applicant to research and know, in order to make a determination as to, does this pencil out? That's up to them, but those were some of the comments that were made from us during the development meeting.
You had mentioned that
Okay,
you
and,
felt,
and I'm sorry, go ahead, Mickey.
no, it's not important. Go ahead.
Oh, I was just, it was probably also not important. I was just gonna say, I just wanted to say that, make sure we had that out there, that they know that if there's approval, because I like this idea, this usage for the site. I think it fits in with the site, it fits in with kind of our, or at least my ideals of this part of town specifically, but it's just the timing of it was my concern of whether or not they're gonna have to come in and ask for an extension or something of that conditional use approval.
But it seems like, I'm hearing a lot of people say they like this project. Now it's just a matter of giving them some sort of nod or mechanism to feel comfortable spending the kind of money and time that it's going to take to invest in something like this. So what's that look like from?
I don't object if they go forward with an approval with the right conditions, right? I mean, if that's what they need, but
I don't know that we could come up with those conditions with what we have.
make sure we.
So what do you think we need to be able to say we could actually formulate conditions we are comfortable with? So tree report,
You
yes.
said tree, you were
I'm tree and geological for the.
geological.
For the, not full geological, but for the parking lot itself. I'm not concerned about the structures.
Yeah, they do have a wall going in there somewhere, I thought, a retaining wall under the parking lot.
Retaining wall along the backside of the parking lot. You know, retaining walls are not required under permit anymore in Oregon, so.
It just indicates that there might be a
potential
geological issue.
I mean, it'd be interesting to find out what would be necessity for that retaining wall.
Right.
Support itself.
Right.
But beyond that, I don't see anything within the scope of the tent structures themselves.
No, I agree with that.
Given what we're talking about, Steve, what are some of the challenges that you see?
You know, I think well, parking lot, I don't know the answer to that. I know that the cost of bringing sewer, water and street, you know, several hundred feet are expensive. I can't ballpark that. I'm sure they'll find out. You know, from my perspective, I think you guys should be getting at a minimum conceptual drawings of the structures, the tent structures, you know, everything that's shown on this site plan. I think you should have something that visually shows you what you're considering so that when it comes back to you and all of a sudden you see down the line, well, that wasn't what we thought. So I think there should be some type of expectation in terms of, you know, the structures, the parking lot, the ADA, the road, what they're talking about, the arborist report. So there's a couple of ways of doing this. First of all, I wouldn't recommend conditions of approval because I don't think we're close to doing that at this point in time. I would suggest maybe a continuation, and I think this information is going to take some time. We could talk to the applicant if we wanted to see what they would need. But if we were talking about a continuance, I would say we want to make sure that they are agreeing to the specific amount of days that the 120-day clock gets extended as well, because I think this is going to take some time. You know, in terms of getting an arborist or some people and different things to get this information together, you know, we could talk to them a little bit, but I'm thinking this is going to take a little bit of time. I would suggest that they come in and meet with staff prior to it coming back to Plan Commission as some of this information gets put together. So we can say, hey, yeah, we think this is good, or you need this yet, or what have you. So I'm thinking 60 to 90 days minimum to even come up with that information. But if you guys wanted to, you know, discuss with the applicant, because we'd have to open the hearing to hear if they're willing to continue it that for amount of time. It's either that, or if they're not willing to do that, then my suggestion would be to deny the request at this point in time because you don't have enough information to make the decision.
Okay. So I think we could make a solid justification for opening the record again. We did not earlier. And that is around a discussion we did not have with the applicant around a mechanism to help them move ahead, hearing us signaling we like the project, but we need more information.
Yeah.
Are we in agreement that we can open the record again?
I agree.
With that in mind, we will open the record again and ask the applicant, what sort of time do you need? So we are considering a couple of different paths. One would be to not to deny and have you guys come back to us with more information, or we can give you a continuance. But for that continuance, because we only have 120 days to rule, city only has 120 days, we would ask for the addition of whatever time you think you need to make a ruling on this. Does that make sense?
It does make
Yeah,
sense.
totally.
Okay.
We for sure don't want you to disprove.
Okay.
So, yeah, my understanding is we're talking about, you'd like to see our risk report, geotechnical relating to the lot and the possibly how it might affect any retaining walls we might need. Schematic level sketches of what the structures would look like from the outside, either elevations or renderings.
Platform.
And what the platforms will look, and a little bit of detailing on how we're gonna do the ADA access and how the paving structures work. We can probably, you're talking about you said a 60 to 90-day window where.
That was thrown out very randomly. You may have.
It could be shorter. I don't have any problem with that. I was just tossing out times that I thought.
About your 120 days.
Exactly, and
Give us an extension to that clock.
I want you to have enough time to get in the information, and I don't have a problem what time frame you want to extend to. I just don't want you coming back, bringing something in and everyone saying, well, we wanted this stuff and it's not ready. So from that perspective, I don't care if it's 30 days, 60, I don't care. It's up to you to choose what time frame it makes sense for you to provide that documentation. Consultants.
Yeah, I don't. Well, don't get this gonna be 50 times. Yeah, I think we can do 60 days.
60 days. So then, and you all stand, correct me if you don't agree. What we would do then is continue our meeting to November and revisit this specific.
Yeah, November's meeting is probably gonna be early,
Yeah, actually,
or maybe November's late this year. Which one?
it was going to be something we were going to be talking about at the end of the agenda as far as Thanksgiving and dates and stuff. Right now, we are looking at Tuesday, November 26th. That was going to be something we are going to be speaking about. And if we're going to continue it, you typically want to continue it to a date certain.
Why does it have to renotice?
So that is the Tuesday before Thanksgiving, correct?
Before Thanksgiving is Tuesday, the 26th.
So I don't know if that's bad for you guys or not. We can do, Christmas. We're gonna also talking about the holidays. Okay.
Are you guys around?
We're around.
We can be.
I'm concerned more about contractors and like their vacations.
Right, that could come up, and that's why I'm suggesting maybe longer. I have no preference in terms of time you guys can do it. I just don't want you coming back and you don't have enough, and then we have to make a decision you guys don't want.
It's your project.
Yeah, I'm happy to extend as long as we need to
Okay.
get all of the, because we want to present as much information as we
Yeah.
can to you all. We just wanted to hear that you guys kind of liked it first.
We're not always no.
Thank you for being easy to please. You made our night.
Do you need a letter for them?
Yeah, we will make a lot.
Well, no, that's what it's, we're letting them set their schedule back by those 3 months, so we're not on the hook anymore.
Yeah.
120 turnaround. That's what this discussion is about.
Gotcha.
So I'm just saying, I imagine that the end of December is a terrible time to do this also.
Yes.
Not a great time.
It is for me. So maybe the end of January, and then you can reset your 120.
The January 23rd meeting, which would be our typical agenda date. So that's like the fourth Thursday in January. So what I would end up doing, just so everyone knows, is I would work with them and, based on this discussion and their agreement, would send them some documentation probably within the next day or, well, maybe into early next week, that says, hey, here's what we talked at the Plan Commission. This is how they approved it. You would sign off on that. And if you wanted, we could look at that January 23rd date, if that makes sense.
Yeah, that's great.
And then they're not on the hook.
Yeah.
If that's acceptable.
Well,
So we're getting an approval from them. They're going to extend the clock by the same number of days.
That's correct.
Okay. That works.
we'll move that meeting. We'll need something from you in writing.
Yep.
To the planning. And
Yeah.
then we'll just revisit this in January.
Great.
Okay, so we,
Yeah, thanks for being willing to play.
telling we're flexible in this and.
Yeah.
Not
Good
always
luck
the-
to you guys.
Much appreciated. Thank you.
Yeah, you just want to see, and everybody gets something good.
There you go.
Thank you.
Thank you.
So we'll close the public testimony portion again and move. Someone want to make a motion there?
I'll move that we continue this till January 23rd, 2025.
Yes.
That the applicants will agree to extend the 120-day clock by the same number of days.
Second,
Discussion? Counselor, will you call the roll, please?
Moritz. Commissioner Alexander,
Yes.
Commissioner Orloff,
Yes.
Commissioner Matusik,
Yes.
Commissioner Bates.
yes.
Commissioner Sinclair,
Yes.
Chair Newton.
Yes. Let's move to our January meeting.
Could I just make one real quick comment?
Mhm.
And then when you guys kind of get some stuff together, feel free to just stay in contact and we can get a meeting amongst ourselves. And that before we get back to this meeting. Okay. Thanks.
Thanks for your time.
Thank you.
Thank you. Okay, we're gonna take, okay, our next item. A legislative item, public hearing ZO 24-03, a proposed text amendment, municipal code, chapter 17.84, short-term rentals. City of Cannon Beach application for text amendment CBMC 17.84, short-term rentals. The application will be reviewed against hearing of CBMC 17.94 amendments and statewide planning goals. Does anyone object to the jurisdiction of the planning commission to hear this matter at this time? Does any commission member believe he or she has a conflict of interest or personal bias? Has any commission member had any ex parte contact? Before we have the staff report, I would like to discuss correspondence we've received. Tell me what time Dean Alterman's letter came in today.
It was after 4 p.m.
It was pretty late. I think we got that together right as the meeting was getting
Yeah,
together.
it was distributed within about 10 minutes of when we received it.
4:28 PM.
4:28. Okay. Bill,
Yes.
we have before us a letter that was submitted at 4:28 with attachments. This looks to be about a 50-page document.
70 pages.
70 pages, thank you. I have not read it completely. Nor am I inclined to want to read it at 30 at night as we sit here. My question to you is, do we have to admit this okay, I'll ask the question. Do we have to consider this in our deliberation on this issue?
And I'm gonna turn off my video. I seem to be having some issues with my connection and that sometimes helps. So let me do that. And hopefully you can hear me, but it looks like my picture is frozen on your screen, so.
We can hear you just fine. Now we can't hear you, Bill.
Maybe he needs video.
Sign language.
All right, can you hear me now?
Yes.
Okay, so I'll try and get this in. As I understand it, you're asking, this material came in at 4:30 today and you're asking whether you have to consider it. The simple answer is yes. you hold a hearing to get public input. And it does make it difficult to process everything when it comes in so late. But it is part of the record, and the point of having a hearing is to allow people to bring their concerns forward.
It would be one form of jamming us and makes me want to read every word. But,
You know, one of the questions that comes up is, do you have to read every word? And sometimes, I think back to those situations where you have geotech reports, I've learned more about geotech than I probably want to know, and I know just enough to be dangerous. But I can tell you a big chunk of that is incomprehensible to me. And so, what you do is you have the material available to you. You get the best impression you can of what they're trying to say, and you make the decision based on the information that you have, and that's in the record.
okay. You or Robert, have you had an opportunity to look through this?
I have briefly skimmed it. I understand, just enough to know what the suggested recommendation being made by Mr. Alterman is, but as far as any sort of in-depth, no, I have not read it.
A lot of it was, there were 5 pages of the letter with just, I think it's a housing report from the county, I believe. I can't remember the end of the attachment to, I can't remember. There's like 5 pages of Attorney Alterman's letter where he talks about the history, going through, certain ordinances, talking about how it was created, how it was dealt with, how it was amended. Talks about some of the housing stock numbers in the city in terms of a lot of the work that Herbsworks been doing. Talks about some of the policies that are related to the comp plan and how this fits in. He identifies Housing Policy 8 and the Economy Policy 2, and just has some general information in terms of who he's writing on behalf. Beachcomber Vacation Homes, Hagstack Luxury Vacation Rentals. So he had submitted this letter on their behalf, and it appears that maybe during some of the public testimony that one of the applicants or one of the owner representatives may provide some additional input that also is detailed in the letter. So we may find out as part of the presentation as well.
Do you know if Mr. Alterman is on the?
He is not.
Okay.
Another request for continuation too.
We have a request for
On this
continuation.
one?
From Anita Duber.
Nope, that was for item number 1, or the school one.
Sorry about that.
This would be one case where
I think I understand the basic gist of this, so I feel like I would be comfortable discussing it when we get to deliberations.
Okay. Well, maybe summarizing it for.
Sure. I mean, should we wait till we're in deliberation?
Yes, I think so.
Yeah.
How do people feel about that? Mickey, maybe some of.
I scanned the letter. I didn't look through the.
Yeah.
Okay.
And I can talk.
Let's go ahead, and we'll just kind of work with what we've got so far. May we have the staff report?
Yes. The City of Cannon Beach Planning Commission is holding its initial evidentiary hearing regarding proposed changes to municipal code 1784 short-term rentals. The proposed action is the relocation of regulations applicable to short-term rentals from Title 17 zoning, Title 5 business taxes, licenses, and regulations. The city has determined that Title 5 is a more appropriate location for these regulations than Title 17 because short-term rental licenses are not land use decisions. Procedurally, they are administered as business licenses for an activity subject to time, place, and manner regulations. Title 5 is the location of the city's regulations regarding other such activities, such as cannabis and psilocybin services, which are regulated through the issuance of licenses and are not land use decisions. No changes to the text of the short-term rental regulations are proposed as part of this action. The applicable criteria identified out of 1794-060A, the staff comment states that comprehensive plan housing policy number 8 states that, quote, the city finds that transient occupancy of dwelling units constitutes a visitor-oriented commercial use in the city's residential areas. In order to maintain the residential character and livability of its neighborhoods and to prevent the adverse effects of transient occupancy of dwelling units on residential neighborhoods, it is necessary to limit and regulate the transient occupancy of dwelling units, close quote. The proposal will not be inconsistent with this requirement, as the regulatory framework for the management of short-term rentals will continue to exist. It simply will not continue to be administered through the zoning ordinance. And that the proposed amendment would not have any effect on the ability of the city to satisfy land and water use. And that concludes the staff report.
Okay. I hate to ask, is there additional correspondence?
This is the only correspondence received.
Okay, we'll move to public testimony. This is a legislative hearing, so quasi judicial disclosures do not apply. As such, the planning commission should commence taking testimony. Testimony, arguments, and evidence must be directed toward those criteria in the comprehensive plan or municipal code which the person testifying believes apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision makers and the parties an opportunity to respond to the issue precludes appeal based on that issue. Prior to the conclusion of the initial evidentiary hearing, any participant may request an opportunity to present additional testimony, arguments, or evidence regarding the application. Planning Commission shall grant such requests by continuing the public hearing or leaving the record open for additional written testimony, arguments, or evidence. Persons who testify shall first receive recognition from the chair, state their full name and mailing address, and if appearing in a representative capacity, identify whom they represent. It's I guess it should be the applicant. Or is that presentation by the applicant?
I guess, went through the staff report. So that was pretty much it. I mean, if there's questions or things like that, we're willing to ask. I think a lot of this came from discussions out of kind of the housing focus group as taking a look at ways of trying to provide affordable housing. Some of the concerns were with some of the issues in amendments that we might make that they could impact the potential for additional short-term rentals. Based on those conversations, the focus group requested direction from the council. The council directed staff to and recommended to council that this section should be removed. The short-term rental should be removed from the zoning ordinance and put into the business section for the reasons that were mentioned in the staff report. Staff took that direction to council and council indicated to staff that yes, move forward with this proposal. And that's why it's here this evening.
Okay. Are there presentations by proponents? No one? Presentations by opponents? Okay. Applicant?
No, other than we're recommending that the plan commission approve this and send it to council for their consideration.
Okay. This is public testimony and move to our consideration.
All right. So if I'm trying to summarize what the Alderman said, basically he's making an argument that housing policy 8 should and has to be a land use decision because it says you must regulate the use of dwellings. The question for us is essentially, do we agree that it must be a land use decision by law, or is it also appropriate that it could be a business decision, just like licenses are regulated for any number of other uses? So that's basically the decision that's before us. And as far as I can tell, that's really what there's plenty of other information in Alterman's letter, but as it, to me, reads, the legal question he's raising is this by nature a land use decision that cannot be moved out of Title 17?
I would think the fact that other people have it in Oregon in their business section is an indication that it can be in the business section of the code.
Yeah.
In fact, I appreciate Mr. Alderman's concern, but it's not really a legal argument. It's more of a, I don't know.
And I think he's a savvy individual and he recognizes that if it stays where it is, it has to go through PAPA for changes to be made. But there is still a full review process for any change anywhere. So at this time, we're not talking about anything that requires extensive level of review because language regulations essentially the same. And not just essentially, but the same.
Yeah, but the door is left open for future changes.
It is. The door is left open for future changes wherever it is in the code.
Right, but if it stays where it is, then I think then it's clearly gonna have to go through a very rigorous process. If we move it into this other chapter 5 or whatever they want to put it into, I'm scared of the move because it just feels like there's unintended consequences wrapped up in this that I'm not capable of figuring out. If we move it to 5 and then change something, I can't get comfortable that it should not have gone through a pop-up process.
So
just because we moved it to 5, we would automatically say, no, it's not required, but I'm not
So
this basis convinced of that.
do you feel that this is fundamentally a land use decision?
I don't feel that I'm qualified to answer that question. I really don't. I mean, I think I'm being presented with information that is so sketchy and I'm so ill-advised that I don't know. But to me, this was an opportunity to streamline a piece of the city's code process. We move it from one place to another where we can make changes more easily. Well, I don't know that that's, I would trust somebody who knew a lot more about its opinion than mine, but it does not make sense to me.
Bill's on the line and I can speak to it. It's not as though there's not still a formal hearings process and ordinance process that goes into any of the municipal codes. Just like we regulate marijuana and mushrooms, that's not in the zoning ordinance. It's in this section, which is kind of like this time, place and manner, not just the city, but many communities in Oregon handle business license or short-term rentals through the business license. So it may not come to plan commission for a hearing and a recommendation, but there's still anytime there's an amendment to any of the ordinances in the municipal code, there is still a hearings process that has to go before the council. They just can't, on their own, say we're making these changes without ordinance amendments and hearings. And I don't know if Bill, if there's anything I'm missing on there that you wanted to add, or Robert.
I do have one thing to build on this, and this goes to the way that these particular permits are administered. And this might address Liz's concern as to whether or not it is a land use decision versus something else. Land use decisions, i.e. a development permit, a CUP, a DRB review, those all have a built-in appeal period, a notice period, things like that go out that STR permits do not have, nor do business licenses. And so that is one of the fundamental differences between, I would say, between that and a, kind of a typical land use decision like a type 2 grading permit or something like that. We're not noticing neighbors. There is no 14-week appeal period. Nobody's going to appeal a short-term rental license to the planning commission. So that may be one thing to consider.
So if I could paraphrase, so what you're saying is that we don't currently treat short-term rental permits as a land use decision in
Correct.
in this community.
Correct. At this time, they're effectively administered as a business license through the Community Development Department.
It's good to know.
And Bill has his hand up.
Go ahead, Bill.
Yeah, to sort of carry on a little bit more and then add something different to what Robert said. When you think of most permits that come before you, most applications, it's, can I build this here now? And once it's built, there's not much ongoing review. There is in some circumstances where short-term rental really is, you know, so much of it is a day-to-day regulation. And that's really what the bulk of the city short-term rental ordinance does, is regulate how short-term rentals operate rather than, you know, how they use the land. The other thing, and this I think is the key piece of Mr. Alterman's letter, is that a land use decision is one that involves implementing the comprehensive plan. And so what Alterman is saying is that your comprehensive plan says these should be land use decisions. It kind of has a point there, but that doesn't mean that in the course of, if this is something the city wants to do, you can't change the comprehensive plan as part of implementing this change from having the short-term rentals in your land use program to having it more sort of in your business program. And that's just something we'd have to look at and, you know, see if that makes sense. You know, and same with you, I just saw that this an hour or so before the meeting, so we need to review that. But this is not insurmountable in any means, and as Commissioner Bates indicated, a lot of jurisdictions do it the same way, so this is not insurmountable.
Thank you.
Now, moving this from our municipal, from where the section is to this business section, there are still going to be guardrails in place if there are amendments to that section through the city council, correct?
That's correct. They would have to go, the only thing that would be different is there wouldn't be a formal notice that we have to send to DLCD because we're not doing a zoning ordinance amendment. So that takes out the plan commission, but it has any type of ordinance that's approved from a code perspective, the rest of the municipal code has to go through a hearings process and an ordinance adoption before council.
I want to weigh in quickly that not every city requires hearings to adopt ordinances. I don't know Cannon Beaches because I don't deal with non-land use ordinances. But we should confirm what.
Bill, we lost you there.
I think he was probably going to say that we should confirm other ordinances also receive a hearing, which in my experience, if they do require hearing for any ordinance.
Sounds like there's a couple of pieces that need thought about a little more completely. Okay. Thoughts?
Bill could hear us or we could hear him. I would like to understand why, because it's in the comprehensive plan, it needs to be in land use, because the comprehensive plan also has economy policies and other factors that I'm not understanding the connection that just because it's in the comprehensive plan, it has to be defined as land use.
I can't hear you, and hopefully I can squeeze this in before the next instability happens. But a land use decision is defined as any decision that implements a comprehensive plan. And so we may move it out of, you know, our Title 17, but it would still remain a decision that implements a comprehensive plan because of because of what it says in the comprehensive plan. You know, we have a lot of economic policies in our comprehensive plan, but there aren't typically decisions in the same way that really affect affected in the same way. You're not issuing permits when you do some of the economic things. There's also fiscal exemption that kind of gets you out a lot of those, but it just, the way, you know, again, I haven't had time to fully review what Mr. Alterman says, but if we say in our comprehensive plan, we are going to regulate short-term rentals through the land use process, then yeah, we're gonna have to change that, you know, and exactly what we have to change, need to review Mr. Altman's letter.
Robert,
Okay,
when you were,
thanks.
go ahead.
It's just a thing.
Robert, when you were reading, I think it was the staff report, you said this is initial evidentiary hearing. Slightly different than what I have in front of me. Do you guys consider this an initial evidentiary hearing?
Yes.
Okay.
This is the first time it's gone to anybody for.
I feel like that gives us license to go. We need a little
more
more
time.
clarity on some of
Mhm.
these issues.
I know this is a very touchy subject right now for good reason, concern with ADUs.
Yeah.
Residents living in the ADU and renting out their houses, so I would like to talk more about it. Definitely.
And legislative amendments, to my understanding, aren't subject to the 120-day rule.
Right.
Because it's not quasi judicial. So there's a little bit of flexibility if there is a desire for a continuance.
And
Makes sense.
we may want to have more conversations about this,
Yeah.
specifically the ADU and what we may want to change within that.
Mhm.
And taking it out of there will restrict our ability to.
Okay, let me pose a question just for my own education, because we talked a lot about, there are other cities in Oregon that manage their short-term rentals as a business. I understood that. There are cities in Oregon that say short-term rentals can only be in certain neighborhoods and not in other neighborhoods. Is that, you couldn't manage that through a business? We don't currently say that in our code, as far as I know, but well, we don't allow them in commercial zones. To me, it feels like that's still, that piece of it can't be moved into the business management piece unless.
And maybe if one were to go there, maybe what you're saying is that the licensing process, the regulatory aspect of do you get a license or do you not, goes to a business title, but that the land use part, which land can be used for this, remains in Title 17. So it's not to say that everything that touches on short-term rentals would need necessarily to be in the same title. Maybe it ends up making sense, but you could separate those two things out.
And there's certain sections, you know, whether it's a permitted or use in these zones that, you know, the different zones, that's going to remain and could be incorporated. And I think it's the same with these other business uses that we talked about as far as the marijuana and psilocybin.
So cannabis and psilocybin do have language stating what zones they can be used in. And it specifically identifies out commercial zones, you know, saying this is a commercial use, it can be done in a commercial zone. At the end of the day, a short-term rental is effectively an application of a residential use. You are taking a home, which is a permitted use in a, you know, in a residential zone. So that is effectively the zoning component. The house itself, the residential use itself, is the land use. The application of that for a short-term rental is being, which zones, which residential zones can a short-term rental be permitted in? That's effectively what would be done. Very similar to how the cannabis and psilocybin codes are stating that those types of uses are limited specifically C1, C2 zones, which are commercial, and it's just simply an application of a commercial building.
It kind of follows the phrase that was used consistently throughout the marijuana and the psilocybin discussions, that in the business licenses, they're managed in time, place, and manner. So that place portion of that is managed in the business license section of for both psilocybin and for marijuana.
Good. So before you move on a continuance, what do you want to get? So we can say we continue based on what conditions, what do you want?
Well, it seems like Bill wanted to think about how to take some of the concerns voiced by the Alderman letter into the comprehensive plan. There might be.
Modify so we need to modify that, or we need a better carve out of which parts go into the business section and which parts stay here.
Yeah.
I think that's more of my concern is that, you know, the licensure makes sense to be in the business section. But I think we don't want to lose our control over the land use.
Okay.
I don't know what that means. Fair question. I will bring back the same thing I'm bringing to you tonight. Our whole idea is to take the whole section and put it there. And so if it's going to be different, you know, there's no reason why modifications can't be recommended and suggested. But that was the direction given, was to take it as is and move it there. And so, you know, based on that, that's what's before you. And after that, you're going to probably have to make a decision one way or the other as to recommending for or against it. I don't know that the material that's coming to you, other than maybe an answer to a question or two, is going to be any different than what's before you today.
I think I would love to hear Bill's analysis.
And I'm good with that. I'm just saying there's not gonna, the language itself and everything that's in there, because the idea was take it as is and change it. So that information staying the same, but the questions could be addressed. So we can continue and try to put something together for you.
Really?
Are there any other pieces here that people want to have made more clear to them, or? Well, I think.
Table it until the next meeting.
Table it.
Could be one of those things. And so what we'd want to do is just make sure we say that we're continuing it until October 24th.
We want a motion for that?
I'll move that we continue until October 24th.
Second.
Discussion. Tessa, will you call the roll, please?
Commissioner Matusek,
Yes.
Commissioner Sinclair,
Yes.
Commissioner Ostrander,
Yes.
Commissioner Morris,
Yes.
Commissioner Orloff,
Yes.
Commissioner Bates,
Yes.
Chair Newton.
Yes. Items moved to our October meeting.
Stacked up an entire docket for next meeting.
Yeah.
Don't answer your phone.
Yeah, exactly.
Thanks. I'm gonna use that one. I was plan commission member, their chairman said.
Executive order.
Yeah. We'll continue to answer.
Yes, of course. Okay, we have, just make sure I got my order here, right? Our next item is a non-action item regarding SR 23-01. Jeff and Marion Taylor previous to the setback reduction application at 1956 South Hemlock. Steve, you want to comment on that?
Yeah, I can comment on this one. So as you all recall, this originally was approved in, I believe it was May of 23. The applicant had submitted building permits, and this was the discussion about the tiebacks and the encroachment and the different things with the wall. And so at that point in time, staff was going to have opportunity to issue a building permit. So the applicant requested the time extension that came to y'all. And at that hearing, the Plan Commission granted the time extension request, but also had a decent amount of discussion with regards to changes to the existing wall. The comments and issues that were discussed were changes to the existing wall, no further encroachment towards Hemlock, concerns with the street and public infrastructure. And the Plan Commission and staff agreed that if there were any changes to the wall, that the matter would be brought back to Plan Commission. In September of this year, Jay, I'm sure maybe we'll have some conversations, because he is very much related into this matter. Not to say that, you know, he should probably be participating or not, but he's working on this one. In September, he provided some documentation to the Community Development Department with regards to the retaining wall. And so the letter informed the Community Development Department that extensive study by earth engineers has identified a subsurface silt shear zone. The existing unreinforced concrete wall with stairs that run parallel to Hemlock Street has been deemed inadequate to maintain the stability of a Hemlock Street with the construction of a new single-family residence. So the existing wall is to be removed. The face of the replacement soldier pile wall is to match the same location as the existing inadequate retaining wall. And that's shown on some of the plans in before. The existing retaining wall included a series of concrete steps to the east of the face of the wall. These stairs are to be replaced and the void is to be, they are not to be replaced. I'm sorry, the stairs will not be replaced. And the void is to be backfilled upon completion of the new soldier pile wall. The replacement landscape steps are proposed along with the stepping of the soldier pile wall and are to follow the existing grade. City of Cannon Beach Public Works Department has been provided the drawings and have given their approval as the replacement soldier wall has been designed to address the silt shear zone. It will improve the problematic stability of Hemlock Street along this section. And staff agrees with the following. The proposed wall is to be located in the same location as the existing wall. The new wall will not be any closer to the property line or to Hemlock Avenue. Public Works Director Karen Labonte also reviewed the proposed wall and is acceptable with the construction of the wall. In fact, the new wall provides additional support and strengthens the area along Hemlock Avenue. And Director Labonte confirmed the following. The original heard the attached letter and she had our Don Rondema, who does a lot of the work on behalf of the city engineer, and taking a look at that. Per the attached letter from our geotechnical expert, which is in here. After reviewed the geo report, he feels this will accomplish what we asked, which was to stay within their tax lot as well as benefit the stability of the road, Hemlock infrastructure and right-of-way areas, and this proposed pinning and the newly constructed wall. Our concern originally was the impact Hemlock when they began excavation for the foundation, and this will address that concern with the stabilizing pinning. In summary, both the city's geotech and I felt that this was a win-win solution to the original concerns expressed by the city. So it's staff's position that the new proposed retaining wall addresses the planning commission and city staff's concern when granting the their time extension request. And the Community Development Department wanted to inform the Plan Commission of this information and will continue reviewing the building permit request. So basically what we're saying here is, hey, yes, it's going to be replaced. It's going in the same location. It's not going any closer than what was originally proposed. It's adding some strengthening. There was a lot of discussion and concern on this that you had with staff. And you guys indicated to staff that you had some concerns. And these were those concerns. And I wanted to be sure at least that I was bringing that back to you before just acting on the permit itself. So this is kind of an informational situation. And so I just wanted to bring it back to your attention.
I noticed that we're talking about this as a non-action item. And I honestly don't remember how. I do remember it was concerning, but the wall was concerning there. I don't remember whether we said it had to come back to us or whether we wanted it to come back.
It was a little bit of both. There was some stuff that it was like, hey, I just wanted, I guess what I wanted to do, there was enough in there that I thought that I wanted to at least bring it back to you to know here's what's being proposed and what we're doing instead of just simply acting on the request because of all the discussion. But I feel comfortable with the proposal. Karen feels comfortable proposal. I don't think it's doing anything different. But there was discussion on the wall and I wanted it brought back just for your information.
So that bridge that we approved the first time through, that's not I mean, it was, they requested a setback reduction, actually, correct? So
Right. So that is remaining. The only question was the existing retaining wall that we approved as is. That everything else, the home itself is meeting all the requirements. It was just that porch, second story porch that was encroaching over.
So I had a couple of questions. One, thank you so much for bringing it to us because I think that's really important. To me, and I don't know that our findings were really reflected this exactly, but to me, that whole decision was based on that wall staying in place and the fact that it's no longer going to be there, to me, actually does make it an actionable decision. I understand that this new design is going to go right back in the same place, but there's an interval between when the old wall comes down and the new wall can be existing that feels dangerous.
I think Karen spoke to that.
They may be able to do that all day, every day. You know, to me, that my whole thinking along that original application was that wall was already in place. It wasn't going to be messed with. That was where my comfort level was. And now I'm being told it's going to be taken out.
That's right.
So I'm not comfortable with it.
I remember that being the theme as well, and that it was more than a discussion. It was more like if it's moved, and I'll have to look, but if it's moved, it comes back to us. I think I'll echo what Les said. It sounds like you guys have done an amazing job, but it is, you know, we talked about precedent a couple of times tonight. I just, especially when we have the neighbor also wanting to do something, I just think we have to dot the i's and t's more carefully than we ever have. And if we said it comes back to us because we're concerned if it's touched, it comes back to us, then it needs to come back to us. And again, it seems procedural and, you know, in this case, we'll probably be in favor of what happened, but it does seem like we better be right on par with that process.
Yeah, so could we maybe ask that you check the conditions as written on the original application that we approved? So that we could get a refresher on how that was phrased?
Yes, but I don't know if there was any type of specific condition written.
There may not have been, but I would just, that's where hopefully we would have put something if we.
This may be one, I don't know that we did. I know we talked about it. But I don't know that we actually looked at that language.
And this is where we get caught up if we are not super specific about the.
I mean, I went back and looked and I didn't see anything.
Okay.
You did that. I knew that was
That was definitely the conversation.
All of the drawings that we looked at that were part of the packet all clearly show and are labeled existing retaining wall, you know, and that was what I wanted to see. The other question, and I know it's getting late about, but is it the intent that this new soldier design will not require tiebacks underneath Hemlock?
Nothing, there's no encroachment. It's all being done on the private property.
Okay, so it might still have tiebacks, but they don't have to go with.
I think there's discussion about tiebacks, but there's nothing going off the property. It's all, the only way it would have needed to go back to council was if it was encroaching in the right of way, and that's not occurring.
Okay, I just wanted to make sure. Thank you.
So if we agree it's a non-action item, I think it's this gets kind of cute again here, Jay. If it's a non-action item, we're not talking about conflicts. If it's an action item, we are. I don't know that anybody wants to go there. I feel like you guys have done a great job on that. And I'm probably comfortable moving ahead, but I don't know how this feels. And, you know, it's a little uncomfortable.
One of the conditions, I don't know how we reel it in.
Yeah, again.
And these lessons.
Lesson learned. Me.
That's rough. Okay. Thank you very much for that update.
All right.
Yeah, thank you.
Yeah.
And we have the tree report.
We're done with that.
Yeah, that was
Yeah.
just information.
Thank you.
Yes, the tree report for the month of August is a total of 5 trees were removed. 1 hazardous, 2 dead, and 2 in conjunction with construction. All 5 had replanting requirements.
Talk about our November and December meeting date.
Oh, yeah, thank you.
November 26th.
And so, if everyone wants to, if we can figure this out tonight, that would be great. If it comes down to us, doing it in October, we just need to know because we got to start telling applicants because their applications are going to be submitted in October for November. So, our idea was November 26th, I believe, is the Tuesday before Thanksgiving.
So for November of 2024, yes. Tuesday, the 26th.
And I think that's might have been what we did last year. Not saying it's right, but that's what we are suggesting. And then December 16th, I think, is actually the 3rd week of December.
That's a Monday.
December 17th would be the 3rd Tuesday. The 3rd Thursday is the scheduled design review board meeting, so there would be an automatic conflict with that. The 26th is the day after Christmas, and if I remember correctly, that is a scheduled holiday.
Yeah,
The city would be closed and it's a bad day.
So maybe
generally
December
anyway.
16th, so I'm not,
So-
17th is the Tuesday. I don't know if that makes any difference. And if we wanted, we could confirm these next month. If we want to confirm them this evening, that would be great. But I just wanted to start bringing it up because we're going to have applicants and I want to be able to tell them, A, here are the dates of the meeting, and B, we're going to have, more importantly, a quorum to take action on the matters instead of not having enough people and people coming in.
Maybe this is something we take up at our meeting next week.
And when we look at the findings,
Yeah.
and that's something that makes sense, so everyone can at least take a look at the times and we can talk about it again.
I know there was a couple dates that people suggested did not work. Felt like in my head, I thought Wednesday, given what people were saying, between 12 and 1 was good for you, or
Yeah, I'm 12 to 1 all week, but Eric couldn't do at least the first 2 days.
no, he was the first couple of days.
Yeah, so I'll be looking probably 12 to 1, Wednesday or Thursday of next week. From the standpoint of the findings.
Okay.
So I think that might be a good idea is everyone can maybe just kind of take a look at their calendars and we'll put this back on there and have a little bit more discussion and maybe be able to confirm something then. As far as the November and December dates.
Wednesday works for me.
I'm fine with Wednesday too.
And Thursday works between 12 and 1.
So at about 2:15 on Wednesday, I get on a flight to Amsterdam.
Oh, nice.
I won't be able to call in.
Yeah.
After that. So, but 12 to 1 Wednesday, I'm sure I can accommodate.
Let's do that.
Do we want to check with, we can, do we want to see Eric and Aaron if they have any thoughts?
I got a thumbs up from Eric.
I'm good, 12 to 1 on Wednesday.
Okay.
9th.
Well,
I think actually it's
The second.
which is the second.
Oh, second. Yes, I'm fine.
Second. Yeah, I'll be fine.
Okay. Let's,
All right, then I will shoot for Wednesday, September 2nd. I'll talk to Bill to, try to make sure we can, he feels comfortable that we can get something put together. And that's what we'll shoot for initially.
and we'll all shoot to have looked at our calendars to talk about November and December meetings.
Sounds good.
Okay. Anything for the good of the order? Even if we had it. Okay.
Yeah, thanks for everyone's help tonight.